the microphone. All right, everyone, please be seated. I hope that everyone had a chance to have a decent lunch. All right, State, call your next witness.
State calls Officer Stewart.
All right, Officer Stewart, could you raise your right hand for me, please? Do you
Yes, ma'am.
solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, and if you'll just state your name for the record, please.
My name is Robert Stewart.
All right, state.
Okay.
Oh, he's gonna say state of Texas. That's
Yes,
okay.
ma'am.
I'm speaking to the state.
Go ahead. Good afternoon, Officer Stewart. Can you please tell the court how you're employed?
I'm a police officer with the city of Selma.
And how long have you been with the Selma Police Department?
6 years, I believe.
And do you have any other law enforcement experience?
Yes, ma'am.
And what is that experience?
I was with the city of Live Oak for 8 years prior to that.
And what do your duties entail with the Selma Police Department?
I'm a patrol officer. I respond to calls when someone requests assistance, perform traffic stops, things of that nature.
And were those your duties on January 2nd, 2020?
Yes, ma'am, they were.
And on that date, were you called out to help with a child custody case?
Yes, ma'am.
Where were you called out?
Sorry, I don't recall the exact address.
Would it be helpful to review your report and refreshing your memory?
That would be great.
Showing you what's been marked as State's Exhibit 6 for identification purposes. Can you tell me what that is?
It's a copy of the supplement I wrote. For the call.
And how do you know it's your report?
I recognize it. It's how I write, and I put my name at the bottom.
Okay. Now, please feel free if you need to review it to refresh your memory. Just don't read directly from it.
Yes, ma'am.
Okay, so where were you called out to?
It was 8139 Ellerston Boulevard.
And is that in Bexar County, Texas?
Yes, ma'am, it is.
And when you arrived at that location, did you make contact with anyone?
Yes, ma'am.
Who did you make contact with?
I'll mispronounce it. Sharita Lee.
And did you speak with her?
Yes, ma'am, I did.
And what else did you do when you arrived at that house?
She explained to me the troubles that she was having in regards to child custody. She asked me to try to retrieve her child from the 8139 Ellerston.
And who was her child?
I'm sorry, I'm trying to look at the child's name. Omari Toussaint.
And approximately what time did you arrive at this address?
I was dispatched at 5:41. I would have responded probably about between 5 and 10 minutes from that time.
You say 5:41, was that 5:45, 1 in the morning or 5:41 in the evening?
5:41 in the morning.
And did you attempt to retrieve Omari Toussaint for Miss Sharita Lee?
Yes, ma'am, I did.
Okay, and how'd you go about doing that?
I responded to home, knocking on the front door, ringing the doorbell. There was no response.
Do you remember anything about the doorbell or the front door?
Yes, ma'am, it was equipped with a video doorbell, so even if the homeowner wasn't home, it would have gone to their cell phone and they would have been able to speak with me.
And were you able to make contact with anyone?
No, ma'am, there was no response.
Were there any cars in the driveway on this day?
Yes, ma'am.
What kind of car was in the driveway?
It was a black SUV, and I wrote down the license plate as 63DB71.
Were you able to ascertain who that vehicle belonged to?
Yes, ma'am, I did a registration check on it. The registration came back to Mr. Toussaint.
Were you able to retrieve the child Omari Toussaint for Miss Sharita Lee that day?
No, ma'am, I was not.
Did you have any other involvement in the case?
After I tried to make contact with the house, I went back and I talked to Ms. Golden Lee. She was explaining the troubles that
Objection,
she was.
hearsay on.
Sustained.
Did you go back to the house at all?
No, ma'am, I believe that was the only time I responded to the house.
Do you know if other officers went back to the house again?
I believe so.
Do you know if any other officers were able to obtain Omari Toussaint from the defendant or his mother?
No, ma'am.
No, they weren't able to?
No, they were not able to retrieve the child.
I'll pass the witness.
Defense.
May I proceed, Your Honor?
Yes.
Officer Stewart, was Sharita Lee the only person that you spoke to that day?
Yes, ma'am, she was the only one that I spoke to in regards to this case.
I'm sorry to interrupt you. Can you remind me, please, what day that was you went out there?
I went out there, it was January 2nd, 2020.
And what other officers are with you?
I was dispatched by myself. It was a separate call because it was in regards to this report. I wrote a supplement to this report.
So you went by yourself,
Yes, ma'am.
and the information that you put in your report, where did you obtain all of that information? Was it just things that Ms. Lee told you?
The information contained in my supplement was what I was dispatched to, what I was asked to do. That was recorded and it documented the vehicle being in the driveway. Seeing any other information anyone gave me.
Were you given any court orders relating to the child?
She had talked to me about them, but I know that other officers had seen them, so I did not review them personally.
So you went to that address without having reviewed any court orders to let you know exactly who should have had possession of the child on that day?
I believe that's correct.
And you said it was January 2nd, 2020 at 5:41 a.m.
Yes, and it was.
So you worked overnight shift then?
No, ma'am, this occurred at the very beginning of my shift.
Okay.
I started at 5 in the morning.
Okay, so you start at 5 in the morning, typically, would you say most people would probably be asleep at that time?
Yes, ma'am.
So that would be one day after New Year's. Are you aware of whether or not Judson ISD is still on Christmas break at that time?
No, ma'am, I was not aware.
You're not aware, okay. Did you look to see what their schedule might be?
No, ma'am, I did not.
Did you know if the child was in school in Judson enrolled at that time?
No, ma'am, I did not.
So you don't know where the child was enrolled, you didn't see any orders. You went and knocked on the door, rang the doorbell. How do you know the doorbell was working?
It's a typical ring doorbell, which I have at my own house, that has a light that on it that you can see that it works, and when you press it, it makes a sound.
Okay, so how do you know it was on anybody's phone inside that house?
I don't.
And then once you left that location without having viewed any orders or speaking with anybody other than Ms. Lee, did you obtain any search warrants or any arrest warrants in this case?
No, ma'am, I did not.
And after you left that location, did you do anything else in regards to your investigation for this case to determine that there was any type of violation here?
No, ma'am, I did not.
Thank you. I'll pass the witness.
Safe.
No further questions.
Is this witness excused or subject to recall?
Maybe excused. We're fine.
Okay, thank you. You're excused, officer. Officer, the rule has been invoked. That means that you can't discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state and the defense attorneys. Do you understand?
Yes, ma'am.
All right, thank you. State, call your next witness.
Take off Sergeant Arturo Perez.
Okay, stand up, please. You can raise your hand for me. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you may take a seat, and if you could state your name for the record.
I'm Sergeant Arturo Perez,
Right, state.
Thank you. Sergeant Perez, how are you employed
with the city of Selma.
and in what capacity?
I'm a patrol sergeant on the night shift.
And what are the duties of patrol sergeant with Selma Police Department?
I supervise the other officers on duty.
How long have you been with the Selma Police Department?
With the Selma Police Department going on 10 years.
And do you have any other prior law enforcement experience?
Yes,
And with who?
I did 4.5 years with the city of Schertz. And then prior to that, I was with Bexar County and then military police.
So in total, how many years of law enforcement experience do you have?
Civilian law enforcement, approximately 15 years.
And on the military side?
I have 4 years active, 6 reserves.
Can you talk briefly about what training experience you get to become an officer?
Yes, after leaving the military, I put myself through San Antonio College police officers certification. And then I applied out and went through a FTO program with whatever agency I'm starting with at the time.
You said FTO program?
Yes, field training officer.
So on January 1st of 2020, were you employed with the Selma Police Department
Yes, sir. It was.
and in the same capacity as a sergeant with patrol?
Yes, yes, sir.
Specifically on January 1st of 2020, were you dispatched to an address in Selma concerning possible interference with child custody case?
Yes, sir. It was.
And do you remember what time you were dispatched?
I do not.
Your Honor, may I approach?
Yes.
I should ask first, did I ask how my mind is
No,
going?
that's,
Would having a copy of your report help you refresh your memory as to what time you were dispatched?
Yes.
So I'm gonna show you what's been marked as safety exhibit number 6. Specifically, excuse me, page 8 of 12. Do you recognize that report?
Yes, sir.
And do you recognize this your report?
Yes, sir.
And specifically concerning, in particular, your dispatch on January 1st of 2020?
Yes,
So if you could review the document but not read directly from it. After reviewing it, are you able to tell me at what time you were dispatched on January 1st, 2020?
approximately 0140 hours.
For us civilians, what time is that?
That's morning time.
1:40 in the morning. And the address that you were dispatched to, do you remember?
I don't know I don't remember the exact. Check. Yeah. It's like 8139 Elsinburg Boulevard.
Okay, is that located here in Bear County, Texas?
Yes.
So when you're dispatched, did you actually make contact with anybody out in the field?
Negative.
And when you were dispatched to that address, did you talk to any witnesses? Did you attempt to make contact with anybody?
We attempted to make contact with the father of the child, but nobody was available.
Okay, and when you mean nobody was available, what do you mean particularly about that?
Nobody answered the door.
So you or somebody else you were with knocked on the door?
Correct.
So after you're done from that address in Selma, do you go back to the police department?
That's correct.
Once you're at the police department, do you talk with any witnesses?
We attempted to make contact with the father of the child to see if there's some kind of one to get this side of the story and to try to figure it out.
And did anybody contact you on his behalf?
That's correct.
Who did?
It was an attorney representing the father of the child.
Prior to that, did you reach out to Mr. Toussaint's attorney or know who his attorney was?
Negative. I didn't know who it was.
Okay. Do you know how he got information to contact the Selma Police Department?
Not exactly. We did leave a voicemail for the father to contact us to try to get his side of the story.
So eventually that attorney called you and were you able to speak with the attorney?
That is correct.
And after speaking with the attorney, what did you do next?
Based on the evidence that we had at hand, the lack of communication with the father, we filed the case as an interfering with child custody.
Was there any indication given to you through your investigation that Mr. Toussaint had any intention of returning the child?
Negative.
So I want to move on to January 3rd of 2020. Did you do some follow-up on this case as well?
That's correct.
Okay. And did you go out to that same address at 8139 Ellerson Boulevard?
That's correct.
And again, that's here in Bear County, Texas.
Yes, sir.
And what was your purpose of going out that day?
Continue to make contact again with the father, try to see if the child was home present.
Okay. And on the 3rd, do you remember what time you went out there?
It was at 0018 hours.
And for civilians?
That's 18 after midnight.
Okay. So 12:18 in the morning?
Yes.
And were you able to make contact with Mr. Toussaint on that day?
Negative. Nobody made it to.
And again, did you knock on his door that day?
It was either me or one of the other officers that knocked on the door.
Okay. But either way, you were out there at the scene.
Correct.
And nobody made contact that you were with on that day with Mr. Toussaint.
That is correct.
So after you finish your portion of the investigation, do you know what happened after that?
I do. There was I didn't have to respond to anything, but I did follow up on I just kind of overheard on what's in place as far as getting the children back. But there was no other involvement as far as me.
And eventually was this case filed with the Bear County Criminal District Attorney's Office?
That is correct.
And for what offense?
I believe it was interfering with child custody.
I'll pass the witness.
Defense,
May I proceed, Your Honor?
yes.
Sergeant Pettis, does the Selma Police Department make it a habit of filing cases based on the fact that a subject of an investigation didn't comply or didn't open his door or didn't answer a phone call? That's something you use to base a decision on whether or not you file a case?
That is not the only reason we filed the case.
But
It
no,
was
sir,
a
I'm sorry,
fatality.
let me interrupt you. Is that common practice for you to either, whether in the course of your investigation or in the police department or an open court, say, we went ahead and filed it for these reasons, and because the defendant exercised his privileges, his constitutional rights, we decided to go ahead and file it because he wouldn't talk to me, he wouldn't open the door for me.
That is not the reason it was filed, ma'am. The reason it was filed is because mother had seen the child.
I'm sorry, I'm gonna object to non-responsive. That wasn't the question that I asked, sir.
That would be overruled.
So let me try it again, sir.
And Judge,
Am
I
I-
believe you overruled the objection, so I believe that this witness should be allowed to answer the question and complete his answer.
That's the question.
The question was whether we filed it just based on somebody not communicating. That is not correct. It's the totality of the evidence at hand.
Okay, so may I restate it, because that is not the way that I asked the question, so I'm gonna ask it again.
You may
in a
ask
different
whatever
way.
questions you wish to ask counsel.
Thank you. Did you not, about 5 minutes ago, tell this jury that in addition to other circumstances, based on lack of communication with the father, we filed this case?
I believe so that was one of the reasons, correct?
And you would agree with me, would you not, that Mr. TOUSSAINT does not have to talk to you?
That is correct, ma'am.
Now, when you investigated this case, you went to the address that you stated, correct?
That's correct.
Did you read certified copies of any orders in this case?
I did not.
And did you obtain information from anyone other than Sharita Lee?
The attorney that contacted me over the phone had sent over an email with documents as well. They were attached to this case.
So you obtained information from Ms. Lee, and you also obtained information from an attorney that at that time was representing Mr. TOUSSAINT.
That is correct.
Okay. And so did you force that attorney to call you?
Negative, and he called through dispatch and wanted to get a hold of the officer that was trying to get a hold of the child's father.
Okay, and did you force him to email you any documents?
He wanted to explain the documents to me. I told him we were still going to, well, I mean, file, it gets forwarded to criminal investigations and they do further investigation on the case.
Are you aware of what further investigation was done in this case?
I am not.
And you said you didn't review any certified copies. Did anybody give you any information about the fact that at that particular time there had been motions filed here in Bear County?
I did not have any other information.
Okay, so you did not know about anything filed in Bear County.
That is correct.
And when you say your investigation you completed in this case, that consists of you getting information from the child's mother, getting information from Mr. TOUSSAINT's attorney, and going out to the house. Is that fair to say?
What was the question, sir?
Is that what you would consider your investigation?
That as far as we could push it at the time, from there it goes to criminal investigations to conduct further interviews if they can.
So does it get assigned to a detective then?
That is correct.
And anytime on January 1st, January 2nd, or January 3rd, 2020, did you obtain a search warrant or an arrest warrant in this case?
That is vague.
That's all I have about this.
Sam, did we approach?
Yes.
Thank you, Judge Mayor Brice.
Yes.
Sergeant Pettis, so just to reiterate, on January 1st of 2020, you attempted to make contact with Mr. TOUSSAINT at the residence, correct?
That's correct.
And again on January 3rd of 2020.
That's correct.
Now, Ms. Gonzalez asked you that, is it the normal practice of the Selma Police Department to take into consideration whether someone has decided not to talk to you or talk to you, in particular, not talk to you into consideration when filing a case? Do you remember that question?
That's correct.
In any given case, and in particular, a offense such as interference with a child custody case, if the person who is a suspect or accused, if they had chosen to spoke with you, would you have taken that into consideration as part of your investigation?
That is correct.
Objection, speculation, Judge.
All right, that'll be on the rules.
Can we approach?
Yes.
Yeah, I'll pass the witness.
Defense.
No further questions.
All right, is this witness excused or subject to recall?
We have to be excused.
That's fine.
All right, the rule has been invoked, but that means that you cannot discuss your testimony with anyone. The only persons you may speak to are attorneys for the state or the defense. Do you understand?
Yes, Your Honor.
All right, thank you. State, call your next witness.
Say call Sharita Golden.
All right, if you can raise your right hand. Please solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God. All right, you can take a seat. And if you state your name for the record, please.
Good afternoon, my name is Sharita Lee.
All right, state.
Thank you, Your Honor. Do you go by Ms. Lee?
Yes,
And do you mind if I call you Sharita?
I don't.
Sharita, where do you currently live?
I live in Memphis, Tennessee.
And how long have you lived there?
I grew up there. I was born in Seattle, Washington. I grew up there as a child, and after graduation from college, I relocated in 2012. So I've been back home since 2012.
So you've continually resided in Memphis since 2012,
Yes,
and you still currently reside there.
yes,
You have an early flight this morning?
very early.
As far as your family is concerned, do you have any kids?
Yes, I have 3 children, 3 sons. They are ages 13, 9, and 6.
Is one of your children, is his name Omari?
Yes, my oldest son.
And I know this might be a little personal, but what is his date of birth?
His birthday is October the 2nd, 2008.
Okay, so currently how old is
He's 13.
he? And in 2020, specifically January 1st of 2020, do you know how old he was?
He was, well, he was like, so,
And who is the father of Omari?
Otis,
Do you see Otis Toussaint in the courtroom today?
yes.
Okay, can you point at him, identify him by piece of clothing?
He's wearing, a suit. quite sure.
And as far as, let's say the person closest to me is person number one at that table, 1, 2, 3, what number would he be?
He's the fourth person,
Okay, so 1, 2, 3, 4.
yes.
And Your Honor, may the record reflect that this witness has identified the defendant. So when you first had Omari, were you and Mr. TOUSSAINT married?
We were not married, no.
Have you ever been married?
I have, but not to Mr. TOUSSAINT.
And as far as Omari is concerned, when did you or Mr. TOUSSAINT find it necessary for a court to enter orders relating first to his possession?
That order was established in Missouri. Otis and I both attended college in Missouri. At the time that I had Omari, he was getting ready to graduate. I was still in school. When he left Missouri, things happened that required me and Omari kind of to be displaced. He left, he took his name off the lease.
Objection,
So I-
Your Honor, narrative and relevance.
I'll sustain the narrative.
So that's my next question. So when you said that Otis had graduated and he had moved, did you stay in Missouri?
I did until I graduated.
Okay. And at that point, was Otis living with you?
No,
Yeah, maybe so.
Yes.
In particular, I'm going to show you what's been already admitted as State's Exhibit number 1, which is an order out of the 19th Judicial Circuit Court of Cole County, Missouri. The Otis Earl George Toussaint, who is listed as the plaintiff in this case, is that the same Otis Toussaint that we were talking about earlier?
yes,
And we see the name Sharita Lee. Is that you?
yes,
And in particular, this order, which you're familiar with, right,
mhm,
was entered in on January 11th of 2011, correct?
yes.
And I should also note, signed by Mr. Toussaint, correct?
Mhm.
From 2011 up until around 2017, was that the order that was in place relating to where Omari was supposed to be, his possession?
Yes.
And can you tell me what happened in 2017 that might have temporarily changed that?
Objection, relevance, Your Honor.
That'd be our rule.
You can answer that question.
So approximately that time, as you stated, Omari has always lived with me. But at that time, I think it was close to Father's Day that year. Otis reached out to me and he expressed that
Objection,
he
you're saying?
Oh. That'll be, the hearsay will be sustained.
Your Honor, it's a statement by party opponent. It's Mr. Toussaint's statement.
Parties approach, please.
So you can tell us what Otis had told you in relation to why things might have changed or going to be changed.
Yes, he asked me for an extended visitation with Omari because he had cancer and he wasn't sure what the prognosis was going to be.
Based on him telling you that,
Mhm.
and based on your interest in your child, love of your child, did you agree to that?
Yes, after speaking to Omari, I asked him how he felt about it, and he said, okay, but I want to make sure.
Objection, Your Honor, hearsay.
That will be sustained.
And you could tell us what, not necessarily what somebody said. I'll ask you specifically when I ask what somebody might have said, okay? But you're saying that you had considered it, and in consideration, you had agreed to it, right? What was your understanding of how long this temporary possession was supposed to be?
He was supposed to finish the 3rd grade school year, so school had already started. He asked to have more visitation with him, and we discussed Omari coming to finish the 3rd grade school year with him in Germany. Yes,
And so that was in June.
yes,
Was Omari able to finish the 3rd school grade in Missouri? I'm sorry, in Germany?
from my knowledge, yes, but I wasn't privy to everything in regards to that, so I would have to say yes, I'm not sure.
And were you aware of, at that time, any filings by Mr. Toussaint that were his request to officially change the possession orders?
I wasn't aware of him. It was like a verbal agreement. And at one point, I would have, like, we wanted
Objection,
to.
not responsive.
Sustained.
So, were you aware at that point that he was going to petition to have them changed in a court?
No,
And this agreement that you reached with him for this temporary, basically extended visitation, was that in writing with him? Was that verbal? How did you make that arrangement with him?
it was verbal first. And then he mentioned something about us putting it in writing.
Eventually, was it put into writing?
Not to my knowledge.
So I'm going to show you what's been admitted as State's Exhibit number 2. So in your dealings with Mr. Toussaint and subsequently, did you come to find out about the existence of this order?
Yes, I did.
Okay, and how did you find about the existence of this order?
I found out about this one in particular from the principal at the school,
And the school being which school?
Whitehaven Elementary.
And is that where Omari attended school?
Yes,
And how did the principal let you know? Did they call you, text you?
I got a phone call first saying, yeah,
Objection, hearsay.
That'll be sustained.
And Your Honor, just for purpose of the record, her answer was just somebody called me, wasn't the contents of the statement.
All right, if it's not the contents of the statement, then that'll be overruled. But if she's going to be speaking about what was said, then that will be sustained.
I understand.
Judge, and I would also object to the leading nature and speaking objections of counsel to say what an answer would have been coming from the witness when she has an answer.
I'm talking about what's on the record.
All right, so ask your question, please.
Thank you, Judge. So the principal called you. And did you respond to that call? And I'm not talking about the conversation. Did you do something in response to that call?
yes,
What did you do?
I went to the school
What was your purpose of going to the school?
to see why he was there, because the principal probably said that he was there.
He being Otis.
Yes,
And when Otis came to the school, without saying what somebody told you, did you come to learn what he was there for?
yes,
What was he there to do
to remove Omari,
from the school?
yes,
And was he successful in taking Omari from the school?
yes.
Do you remember what date that was?
October the 15th of 2018.
So October 15th of 2018, Otis takes Omari from the school. And I was in Memphis, Tennessee.
Yes.
And at that point, was Otis residing in Memphis?
No, he's never resided in Memphis.
And at that point, were you presented with a copy of what's already been admitted and what's on the screen in State's Exhibit number 2?
I would like to see the signature page because I saw
Objection,
this.
Your Honor, non-responsive.
I gotta be sustained.
So just listen to my question and see if you can just answer that one.
Judge, may we approach before this is answered?
No, ask your question.
Thank you, Judge. Were you aware of an order in existence at that point? Were you made aware of an order that, to your knowledge and understanding, changed the Missouri order in 2011?
No,
So after you said it was October 15th of 2018, when is the next time you had possession, physical possession of Omari?
that was March of 2020.
So from October 15th of 2018 up until March of 2020, you never had physical possession of Omari.
No, I did not.
And during that period of time, what's been admitted as State Exhibit number 2, which is on the screen, the order from Clarksville, Tennessee, was that appealed and vacated by the Tennessee Court of Appeals.
Yes,
And do you remember when that happened?
I got that response from the Missouri Court of Appeals in October of 2019.
So I'm going to show you what's been admitted already, the State Exhibit number 3. And it's fair to say that that shows that it was, the notice filed date was October 10th of 2019.
That's correct.
So even after October 10th of 2019, up until March of 2020, you hadn't seen Omari.
No, I had not.
So after this Tennessee order was vacated, you still didn't get to see Omari.
No, I did not.
And you didn't have possession of Omari.
No, I did not.
When Mr. Toussaint took Omari from school, what, do you know if he was in possession of Omari's passport?
Not at the time. I had Omari's passport.
Did you give Mr. Toussaint Omari's passport?
I did not.
But subsequent to that, Omari was taken out of this country,
Yes,
despite you not giving Mr. Toussaint or anybody Omari's passport.
that's correct.
As far as Facebook is concerned, were you previously friends with Otis Toussaint on Facebook?
Yes, I was.
And do you remember about what year you would have been friends with him on Facebook?
That was back in 2006, my freshman year of college. That's when we met and added each other as friends on Facebook, and so
Okay.
2006.
So from 2006 up until, I want to say, let's talk about October 15th, just say October of 2018. did you know Otis Toussaint to have that same Facebook profile?
Yes,
And what did you have access to it? Meaning, could you view his profile?
yes,
In particular, in reviewing his Facebook, which you had access to, did you come to find out how Omari was able to leave the country despite you not giving a passport to Mr. Toussaint or anyone else?
yes.
Your Honor, may I approach?
Yes.
All right, Sharita, I'm going to show you what's been marked for identification purposes. And states exhibit 7, 8, 9, 10, and 11. You should look at this drawing real quick. Do you recognize these documents?
I do.
Okay. And without telling me specifically what they are, do they generally relate to Mr. Toussaint's Facebook account?
Yes, they do.
And in particular to a post on his Facebook account?
Yes,
And do what's reflected in states exhibits 7 through 11 truly and accurately represent or depict what his Facebook profile looked on those days?
yes,
And in particular to these exhibits, are they screenshots or printouts?
yes. There are screenshots that were then printed. Yes,
Okay. And did you take these screenshots?
yes,
And states exhibits 7 through 11, do they depict what you subsequently learned about Omari's passport?
yes.
And at this time, state would move to the states exhibits 7 through 11. I'm tendering to the defense for inspection and previously tendered to discovery.
Any objections?
Yes, Judge, we object. It's a violation of our motion limiting and board voting.
If I can see states exhibit 7, 8, 9, 10, 11. All right, objections are overruled. States Exhibit 7, 8, 9, 10, and 11 are admitted.
Thank you, Judge. May I publish?
Yes.
I'm gonna show what's been admitted in States Exhibit number 7. So on the top of States Exhibit number 7, you can see that this is relates to OTIS TOUSSAINT, correct?
Yes.
So, and this was a post he made in the morning.
Mhm.
And I want to jump to, so that we have a context about the dates. It says Thursday. As far as States Exhibit number 9, you're familiar with how Facebook works and how you can post. and things like
Right.
that.
Yes.
So what's depicted on the bottom of States Exhibit 9, like pictures and attachments to the post.
Mhm. Yes.
And in particular, States Exhibit number 11,
Yes.
which was this a picture attachment to that post?
Yes, this was one of the attachments.
And the date reflected on this is that, again, this is a United States Department of State passport will call pickup receipt. And it says it will be, the passport for the above mentioned applicant will be ready on Wednesday, October 17th of 2018.
Yes.
So this date here, when it says Thursday, relates to October of 2018.
Yes.
If we could go through this for a second. If you can, go ahead and read what's on this screen for me.
It says, let me minimally detail the past 36 hours. Super tired and adventurous journey because his passport is lost. Okay, challenge accepted. 3 hours drive at 3 a.m. to Clarksville to get judge's permission to get passport solo. 3 hours back to Memphis to get things.
Then continuing on,
Six-
I'll move on to the next one. Continues. States Exhibit number 8.
6 hours drive at midnight to Atlanta to the passport agency for an 8 a.m. appointment, forgetting that I jumped 1 hour at a time, knowing I could potentially be denied while anticipating a 3 p.m. flight to Germany. Make the 8 a.m. appointment, 12 p.m. passport confirmation, 12 hours flying back to Germany.
Continuation of that, starts the bottom, and the middle of States Exhibit number 9.
2 hours, 12 hours flying back to Germany and 2 hours drive back home.
Okay, and you can see this picture right here where my finger is, has some yellow in it.
Yes.
That further blown up in States Exhibit number 10. Is that the same photo?
Yes, this is the same photo.
In particular, it looks like something is circled on that picture. And what's that circle?
It says primary evidence of sole authority to apply, such as a court order, or
And you can see, did you draw that circle around that particular provision?
I did not.
And you can see in States Exhibit number 9, it appears that that's the same thing that's circled, right?
Yes.
So did you give permission for Omar to get a passport?
I did not.
On October 15th of 2018, were you aware that OTIS TOUSSAINT was taking your child to Germany?
I was not.
In written or verbal, did you give permission for Mr. TOUSSAINT to take your child away from October 15th of 2018 to March 2020?
I did not.
Show you what's been admitted in States Exhibit number 1. Particularly, this is relating to the custody order from 2011 in Missouri. It says in number 2, ordered that the parties will have joint legal and joint physical custody of the minor child, correct?
Yes,
So from October 15th, 2018 to March of 2020, did you have joint physical custody of Omar?
I did not.
So is it fair to say on or about January 2nd of 2020, did you have custody or possession of Omari?
I did not.
And did you have any time between January 2nd of 2020 up until March of 2020 have physical possession of Omari?
I did not.
Sure, I'm going to show you again, safety exhibit number 1, which has been talked about. Number 3, it says order that the defendant will have primary custody of Omari Byron TOUSSAINT during the calendar school year.
Yes,
So from when this order was entered in 2011 up until October of 2000, I'm sorry, October 15th of 2018, how did this particular provision play out for y'all?
Omari lived with me. He was in school in Memphis. Like I said, once we moved back from Missouri, he always lived with me. I always had him registered in school. I was always the only person as far as parents on the pickup list. So,
While he was in school, you got him marked, right?
yes,
Was it ever a problem up until 2018?
never a problem.
I'm going to show you on number 13 of this. This was in the 2011 order. It says it's ordered that each parent will always keep the other informed of his or her address and telephone numbers and will notify the other parent within 24 hours of any changes, right?
That's correct.
When Otis took Omari to Germany, did he keep you informed of his address and telephone numbers?
I had his original cell phone, but if he had any subsequent numbers, I didn't know him. So
When Otis moved to Selma here in Bear County, Texas, did he inform you that he was changing addresses?
he did, but it was after he had already been here and I had found him, basically.
Okay. And so when he first moved here, did he tell you that?
No,
And how did you find out his address here in Bear County?
like I said, he sent it to me, but it wasn't initially. It was like after the fact, like, oh, like,
And so my question to you is, how did you first find out his address here in Bear County?
from what I can remember, it was so long ago, but I think it was like I said, an email that he sent saying, hey, this is the address, but it wasn't his address, it was his mother-in-law's address. So it wasn't his physical
Objection,
home
Your Honor,
address.
non-responsive.
Sustained.
And Sharita, do you recall ever getting any mail to your house regarding Mr. TOUSSAINT's address?
No,
In January of 2020, did you come to Bear County?
Yes, I did.
And why did you come to Bear County?
I came to Bear County because that was when I had information as to Omari's whereabouts.
And how did you get to Bear County on that day?
My mother and I drove. We drove to Bear County from Memphis.
Karen, may I approach?
Yes.
All right, Sharita, I'm going to show you what's in Market States Exhibit number 12 for identification purposes. You look at that document, do you recognize it?
Yes, I do.
And you can see it if you want, just so
I'm
let's
sorry.
make sure.
Yes, I do recognize this document.
Okay. And is this a statement that you made, a written statement that you made to the Selma Police Department regarding this case?
Yes, it is.
If you could just read it to yourself, not out loud. When I mentioned mail coming to your house, does this help refresh your memory into that?
Yes, I thought you meant like regular, like postage mail, but as far as like a certified, like I guess it was like a serve of some sort, yes, I do.
Okay. And is that when you first learned Otis's address here in Bear County, or was it at a different time?
That's when I first realized what that was.
And subsequent to that, is that when you drove down here to Bear County?
Yes. Mhm. Yes.
And when you came down here, you spoke to officers with the Selma Police Department,
That's correct.
and you made reports with them.
That's correct.
And do you recall specifically that piece of mail that you got that was certified? What it was in relation to?
It's been so many documents. I don't remember the exact details of the letter, but I think from my memory, it was some type of notice about him being here in Texas. Texas was my original order.
Your original order date of 2011.
Yes.
When Omari was in Germany and subsequent to that here in Bear County, were you able to communicate with him?
No.
Did you ever get to talk with him on the phone?
Oh, it would be situations where, like,
And just answer this first question.
yes,
Did you ever get to talk with him on the phone?
yes,
And
but minimal, very minimal.
how would you get to talk to him on the phone?
Omari would call me and he would say hi and he would hang up. It wouldn't, there was no conversation about what was going on or any of that. It was like, hi. And I'm like, hi, son, how are you? And then he'll say he's fine.
Objection, non-responsive.
And then
Sustain.
And when you were able to speak with him on the phone, was that because you called him or he called you?
No, it was because he called me.
And did you try calling Omari and Mr. Toussaint during this period of time between October 15th of 2018 and March of 2020?
Yes.
And were you successful in reaching him?
No, I was blocked.
So when you tried to call him, the number would come back that you couldn't even call.
Yes, that's correct.
Your Honor, at this time, say the path for this.
Right, defense, yes.
I'm sorry, can you say your last name for me?
Lee,
Lee, okay, if it's okay with you, I'll just address you as Ms. Lee. So at the time, in 2009 or so, that's about the time that you separated from Mr. Toussaint?
roughly, yes.
Okay. And isn't it true that the reason you separated was because he was away for military training, when you came back, you were with somebody else?
That is not true.
Okay, so after you separated and you moved to Shelby County. When you moved to Shelby County in about 2012?
Yes,
Okay, and so when you moved to Shelby County, what did you file to have your order registered there?
I didn't file anything.
Okay, and how long did you live there before Mr. Toussaint moved to Tennessee?
I don't know when Otis moved to Tennessee, so I can't answer that.
So you would agree with me not that in 2014, well, let me back up, I'm sorry. In 2011 is when the Missouri County order was signed, right?
Yes,
Okay. So when we say the words plaintiff and respondent or plaintiff and defendant, Mr. Toussaint is the plaintiff, right? Because he filed those documents so that he could have some rules in place for how visitation is working and how child support is working.
that's not true.
He did not, I'm sorry, he did not file those documents?
Well, he may have filed them, but that wasn't why he filed. them.
Objection, non-responsive.
That'll be overruled, that would be overruled.
Okay, so let me ask you again. Did Mr. Toussaint file that lawsuit for custody and visitation in Missouri County? The order that we've addressed is the 2011 Missouri County order.
Yes,
Okay. And then some point after that is entered. You move out of Missouri County, and then later Mr. Toussaint moves out of Missouri County.
he had already moved. No, that's incorrect. He had already moved. He graduated before I did. He left for training. He was already gone.
Okay. So either way, there's a Missouri County order that he filed for in 2011. Yes,
I've
right?
already said yes.
Okay. So then in 2014, there's another agreed order, right?
No,
For child support?
no, that was a part of the 2011. He started paying child support in 2011.
Objection, non-responsive.
Overruled.
So in 2014, there was not an agreed order that moved to Tennessee, not in Missouri, in Tennessee.
No,
Your child support was never modified.
no.
So is it your testimony that there was never any other hearings in court from 2011 in Missouri to October 2017? Is that your testimony?
I'm not sure what you're getting at. I'm not sure what you're asking.
Well, I'm simply trying to refresh your memory that there were agreed orders set in place in 2014 in Tennessee.
No, there were not. I had never set foot in Clarksville, Tennessee in 2014. So there couldn't have been an agreed order if I'd never been there.
Were there any orders, agreed or not?
The only order that I've ever had is the Missouri order, and that's why it's the one that's still been in effect. I wasn't a part of what he
Okay,
did
I'm
in
sorry,
Clarksville.
that's objection, non-responsive.
That'll be overruled.
Then in 2017, you agreed with Mr. Toussaint, did you not, to allow your child together to go to Germany?
Yes, for an extended visit. To finish the third grade school year, like I previously stated.
And while Omari was in Germany, you were allowed visits with him, were you not? Electronic communications?
When he was visiting,
Yes or no, ma'am?
initially, yes, but not after he took it. We're talking about 2 different times.
And in 2017, is that when you filed to have the 2011 order registered in Tennessee?
I didn't file anything in 2017. It was 2018.
Okay, so in 2018, that's when you filed?
In 2018, I asked for the Missouri order to be transferred to Tennessee.
So when Omari came back from Germany, from his visit with his dad, you want to approach the witness?
Yes.
Let me show you what I've marked. This defense exhibit 2. I'm gonna ask if you recognize that.
No, I don't recognize this on the back. And this says Sharita R. Bryson. My name has not ever legally been Bryson. My name has always been Sharita Goldley.
So it's your testimony that that is not your signature there, ma'am, on the second page? Is that your testimony?
No, because my name has never been Bryson.
Okay, so that's not your signature?
No, it's not.
And so anything that has a cause number with Tennessee, Clarksville, you're saying was never in effect?
No, because when I first saw that, I had never been in Clarksville. It's hard for us to have an agreement if I've never even been to Clarksville. I only went to Clarksville once we wanted to get all of that set aside. I had never been to Clarksville before then.
Did you not notice that your child support ever changed?
My child support never changed. I haven't gotten child support from OTIS in the state of Tennessee. I have never gotten child support from OTIS in the state of Tennessee. That child support order was for Missouri and it was $484.
All right, this time I'm gonna offer in evidence states, I'm sorry, defense exhibit 2 intended to state.
Judge, I don't know the relevance at this point. She says this is not hers. This is not a certain.
I need to see states, I'm sorry, defense exhibit number 2, please.
Yes, Your Honor.
State's objection to defense exhibit number 2 will be sustained.
Thank you, Judge.
So in 2017, after you make an agreement with Mr. TOUSSAINT to allow Omari to go to Germany, he's there for an extended visit, right? What you call an extended visit, correct?
Yes.
Okay. Now, in July of 2017, isn't it correct that there was another order entered in Tennessee?
No,
There wasn't ever another order entered.
no, it's,
Okay, so
you
then
said
what was-
another order, what do you mean, what order?
I mean, an agreed parenting plan and an order that designated that Omari would be going to Germany with his dad, and that the split would now be 200+ days and 80
No,
days.
no.
So then, ma'am, what was vacated by the opinion in 2019?
Okay, I can explain it to you.
Well, which order was it?
It was the conjured up Clarksville order that he had. I never agreed to that. That was something that he did when he was in Clarksville. By the time
Ma'am,
I
sorry to
saw,
object, it's still
I'm trying to
unresponsive.
answer the question.
Overruled, you can answer the question.
Thank you. At the time that I saw that, I had no knowledge of Otis doing anything in Clarksville. I had not been to Clarksville. We did not have a court date. It was not anything on the record. I had never set foot in Clarksville. The time that I went to Clarksville was to ask for whatever he had to be set aside because we were already having litigation in Tennessee. And they told me in order for it to be sorted out, who's is right and who's is wrong, I would have to go through the Court of Appeals. So the Court of Appeals job was to look at my original order from 2011 and look at what he had from Clarksville from whenever. And they decided that the 2011 order was the status quo. And they dismissed whatever it was that he had because it wasn't
Objection,
on the
Your Honor.
record.
I'm sorry. Your objection? to the last-
Unresponsive and.
I just answered the question.
Just a moment. It's gonna be one person speaking at a time. So questions will be asked, and then you can answer. If there are rulings to be made, I'll make those rulings. Your objection is overruled. You may ask your next question.
So in 2017, Omari came back, right?
Yes,
And how did he get back?
he flew.
Okay, and when he flew, you took physical possession of him, right?
Yes,
Okay, and then when it was time for him to go back to Germany, you refused to turn him over again, correct?
incorrect.
So then why were you held in contempt for violating an order?
I wasn't held in contempt. He was never supposed to go back.
If
I was
there
never
was,
held in contempt for anything.
if there was not a 2017 order that had been entered by the court, how was Mr. TOUSSAINT allowed to go back to school and take custody of him as you testified to the jury
He
earlier?
wasn't allowed to. He
But-
wasn't allowed to. He did that on his own merit. Nobody told him to do that.
Nobody but the court order.
No, there wasn't a court order.
Yeah. you
That is why
testified-
they, that
I'm
is
sorry,
why
I'm
they.
sorry,
think-
I'm asking a
No,
question.
stop. Everyone approach now. All right, ask your question.
Did you not say earlier that Mr. TOUSSAINT went to the school to get Amari and he had a court order?
Yes, but the court order that he had didn't have any signatures on it. It was a blank order. And the only thing that was on it was my signature. And the way that I know that is because the principal printed it off and he gave me a copy. It did not have Otis's signature on it. It did not have a state seal on it. It didn't have any fixings that tied it to be a regular court order between two people. So that's what he showed up at the school with the first time he tried to take Omari. That was the first time.
Ma'am, were you ever instructed by a court after Amari came back from Germany? Were you ever instructed by a court to return the child to Mr. TOUSSAINT?
I was not.
So is it your testimony that at no time were you ever held in contempt by that same court?
I was not.
So then in the opinion, when it says they vacate the order and there's an issue with the effectiveness of the order, just the date, what are they referring to? When they say, I'm sorry, let me finish, please. When the opinion says in reference to Mr. Toussaint's contempt action, what are they referring to?
They are referring to his Clarksville order. They're not referring to me. I'm the one that went to the Court of Appeals, not Otis. They're referring to what he has, and that's why we are back to the Missouri order as being the status quo, because what he had was set aside, not what I have.
What he had in 2017, would you agree with me, pertained to both parties? Both parties were ordered to do something or to refrain from doing something under that order.
I disagree, that's incorrect.
But the court agreed, correct?
The
Because
court
that's
did
why
not agree, they set it aside, they did not agree.
the Court of Appeals set it aside, correct?
Yes.
But the judge at the trial court level, he ordered you to turn over the child, did he
He
not?
did not, he did not, he did
In
not.
fact, he also ordered you to turn over the passport
He
of the
did
child,
not.
correct?
No, ma'am,
And you did not do that, did you?
he did not order me to do that.
And it's true, is it not, that because you failed to do that, that is why Mr. Toussaint was allowed to get a second passport under emergency
That
circumstances?
is incorrect.
So I'm going to talk to you about State's Exhibit 3, which has already been admitted, okay? Okay, I'm reading from this paragraph right here. In their appellate briefs, both parties agreed that mother and child left Missouri in 2012, relocated to Memphis, Tennessee. Father states in his brief he had been living in Clarksville, Tennessee for more than 6 months as of June 2014. Okay. Then father files a petition to modify child support in juvenile court in 2014. So you've already testified before the jury that that never happened, correct?
That's correct.
Okay, but here in the opinion, it says that they are taking that as what happened.
They're saying that because of what he gave them. I have not ever received child support from Otis in the state of Tennessee. That means that we wouldn't have had anything to do with the Missouri order. I have never gotten a payment from him through the state of Tennessee for child support. It was Missouri. That's what
But
he
you would
told
agree
them.
with me, would you not, that he continuously paid child support when you were going by the order? He continued to pay child support
He paid up until he had Omari.
up until you had the
Yes.
agreement of going to Germany.
Yes, when
Excuse me.
I'm trying to finish my sentence. When Omari went for an extended visit, I told Otis that I felt it would be fair if he didn't pay child support while Omari was visiting. But I didn't say, like, as far as him getting child support in Tennessee, that never happened. I don't have any record of having child support from Otis in Tennessee. It was not Tennessee.
But what we do have is an opinion that recognizes a valid 2014 order that you say never happened. That says modifying father's child support obligation to $322 per month. Father's attorney and mother as a pro se litigant sign the agreed order, correct?
No.
Then it goes talking about the parties living in Missouri, that none of you all lived in Missouri in 2017, right? So everybody can agree on that, okay? And in that paragraph, it continues to talk about that there was a parenting plan that was signed and agreed to.
All right, everyone, I'm being told that a break is needed. Is that correct?
Okay.
Okay, the deputy was telling me that someone asked for a break. I'm sorry, you can continue.
Okay, may I approach the witness, Judge?
Yes.
Show you what's been marked in State's Exhibit 2. Submitted already. And what does that say on top?
It says agreed order.
Okay, and is this the same order that was presented to the principal of the school when Mr. Toussaint went to pick up Omari from school back in the States?
I need to look at it to be able to see. It could be, but like I said, it didn't have anything on it, so I would say no, because this doesn't look like exactly what I saw. When I saw it from the printout, it wasn't any signatures or any of that on there, so, no.
You would agree with me, would you not, that when we read the opinion and it talks about the 2017 order from Tennessee, that that's this, correct?
I don't know
Okay,
if that's what it is, because like I said, I didn't agree to it.
but you did receive the opinion, correct?
Yes, I did,
You did present it to Selma PD, correct?
I did.
Okay, and so in that opinion, it talks specifically about the attached parenting plan. The attached parenting plan order is specified as agreed. Let's see if I can, there we go. And lists the state of Tennessee and the Montgomery County Juvenile Court at the top of the document. The plan states that it modifies an existing order dated January 2011. In this new plan, father is designated as the primary residential parent with 285 days to father and 80 days to the mother. The plan also states the mother will have the child each year from June 1st to August 1st. Now, Omari was returned to you the following summer, correct, at that time?
Yes,
Okay, and then subsequent to his return, you refused to give him back to dad when that visitation was over, correct?
because that wasn't our agreement. If you go down, if you have this document up, if you go down, you'll see at the bottom where it says what I had to say. I did not agree to send Omari back to him. The agreement was for him to come to finish the 3rd grade school year because Otis claimed to be sick. I did not say that I was going to send him back. That's what he wanted. That's not what I agreed to.
Okay, mother signed the parenting plan on July 19, 2017. Father did not sign the parenting plan, but his attorney signed it. The juvenile court judge signed the permanent parenting plan on July 25th, 2017, the same day the agreed order was entered. Okay, so you agree with me when I say that the order I showed you is what we're talking about here in this opinion, correct?
I guess that's what you're talking about.
Okay, and so when you refused to turn Omari back over per this agreement that we're talking about right now, okay? then Mr. Toussaint went and filed a petition for contempt, right?
Yes, but they did not hold me in, in contempt. I was never punished or any of that.
In July of 20. So in July of 2017, based on that order, Mr. Toussaint filed this petition for contempt because you refused to turn Omari back over, okay? And at that time, you weren't allowing any communication with Mr. Toussaint, correct?
That is incorrect. At this point, Otis and I, when Omari came back,
Objection, non-responsive, judge just asked.
That'll be overruled. You can answer the question. You may answer.
okay, at that time, Omari was supposed to be with me. I did not send him back because I did not have to send him back. We had an agreement that he would be there for the remainder of the 3rd grade, and he would come back and everything would be just the way it was. This is what he told them. That doesn't make it factual just because that's what he told them.
Okay, well, what about this? As a consequence of father's petition, the juvenile court entered an ex parte order and attachment ordering the return of the child to father's custody immediately. The juvenile court also ordered that mother return the child's passport to father. Is that a fact or not?
No, at this point, I had not even set foot in Carsville. That's what I'm trying to get you to understand. He told them one thing and it was another reality going on. So by the time he did all of this in Clarksville, I had no knowledge of it. By the time I got to Clarksville me and my lawyer to try to rectify whatever this is, Otis had already done all of that. He had already planned all of that. I had never even said, it's hard to have an agreed order if I've never set foot in the place.
Right.
I had no
and you bring-
business in Clarksville.
And you bring that all up in the opinion, correct?
Yeah, I paid a lot of
Right.
money to bring it up.
And in fact, in the opinion, I'm sorry, not in the opinion, in the trial court, when that was presented, when you presented that argument to the trial court said, no, that's incorrect, because that document, that parenting plan is notarized, correct? It was a notarized document. And in order for something to be notarized, defendant would have had to have proven who she was, right? So they addressed that in here. And so the other thing they say in this opinion is, well, it's not an issue of mom not having known because we find that she knew because she signed it and it's notarized. It's more of a legal technicality, right? Because there was no certificate of service. And they even talk about, do you remember the opinion where they talk about the fact that even though one party did not sign it, which was Mr. Toussaint, that his attorney signed it and not sufficient. That the issue was no effective date because no certificate of service.
Your Honor, I'm going to object to this extremely compound question. I don't understand what
Sustained.
exactly asked.
I'll make it simpler, Judge. Do you recall them addressing those issues in this opinion?
I'm not sure what issues you're talking about. You said a lot.
Okay, so now do you still maintain that you were never held in contempt?
I was never held in contempt. I went home that same day. There was no contempt. They dismissed, they set all of that aside and I went home. I was not held in contempt.
Do you still maintain that the court never ordered you to turn over the child to Mr. Toussaint?
They did not.
You still maintain the court never ordered you to turn over his passport?
They did not. I had representation at the time and for me and my lawyer, I did not have to do any of those things. I did not do that per se.
And so in the conclusion where it reads, we hold that the juvenile court's July 2017 order has no effective date of entry and cannot be relied upon as a basis for father's contempt action. You would agree with me, would you not, that in the end, you weren't held in contempt because of that technicality?
I can't say what the reason was. All I know is that they set it aside because it wasn't right. That's what I can attest to.
And you would agree with me, would you not, that you did go back to Shelby County and you tried to file things there, correct?
I don't think you're saying things. I don't know.
Did
what
you file
things are.
anything in Shelby County? Did you file anything?
She's gonna have to be more specific. I don't know what things are.
Ma'am, did you ever file a lawsuit in Shelby County? Did you ever go and file a request for your order to be registered in Shelby County?
And Judge, I'm going to object specifically to the ambiguity. If it relates to child possession, it might be relevant, but any suit, that's not necessarily relevant.
All right, that'll be overruled. Ask your question, please.
Did you file anything in regards to child custody in Shelby County?
What I asked Shelby County to do was to register my Missouri order in Tennessee. That is what I asked the court to do.
And in fact, at some point, you went back to Shelby County and asked for the child to be returned to you, right?
Absolutely.
And they said no, correct?
No, that's not what they said. They told me that I needed to go through the Court of Appeals process and all of that. And once I got the mandate, Otis was supposed to return Omari because it said we were returning to the status quo, which means the 2011 order. At that time, after Otis received the mandate in October 2019, he still refused to give Omari back. It was never said that I had to give Omari to him.
Wasn't there a point where you asked for relief from that court and they denied it and said you need to be back in Bexar County?
That was only after Otis introduced Bexar County to Tennessee, because we were already litigating in Tennessee, so for him to jump to Texas didn't make sense.
Well, but at that time, the child had lived here for 6 months, correct?
Only because he took them. I mean, at that point.
Right, because the court ordered you to turn.
They
him over.
didn't order me to take, if they ordered me to give him, why did he take him? If that's the case, I would have given him to him. I wasn't ordered to give Omari to him. He came and forcibly took him.
Right, because that's what the court gave him.
No,
permission
they
to do
did not. They did not. Otis took it upon himself to do that
With the court order
with a falsified court order.
that was noted.
Because
in
we
your
were already
opinion.
litigating in another state. So how could he jump to Texas for litigation and we were already litigating in Tennessee? I have been in the same
I'm sorry,
place.
Judge, I did not ask a question. I apologize.
All right, you don't have to wait till the question is asked.
Okay, yes, ma'am.
Judge, I'll pass the witness.
All right, stay.
Just a couple follow-up questions. By any chance, do you know what an ex parte order is?
Could you explain it to me?
But I was asking, do you know?
Yes, I've heard of the ex parte.
Is your understanding that it's an order that is issued and one party might not be present
Objection,
for
Your
it?
Honor, reading.
I'm
That's
asking us for
sustained.
understanding. As far as when Mr. Toussaint told you that he wanted to take Omari for an extended visitation in Germany, you agreed. And he said the basis was that he had cancer and he was sick, right? Do you know whether he actually had cancer?
He told me
Objection, Your
that he
Honor,
did not.
speculation.
That'll be overruled.
He told me that he did not have cancer after that.
It wasn't true.
It was not true. This was also addressed in the November
Objection,
2020
non-responsive.
hearing.
That'll be sustained.
Can I get the, no. Yeah, I'm sorry, thank you. I'm gonna show you two previously admitted exhibits. I'm sure we understand the same thing. I'll show you what's been admitted in state exhibit number 5 as it relates to a cause here in Bexar County, Texas. Sharita Lee, is that you?
That's correct, that's me.
And Otis Toussaint, same Otis Toussaint sitting right here.
Yes.
And in this, it says that This is a formal request to register an order under the Uniform Child Custody Jurisdiction and Enforcement Act of section 152.305 of the Texas Family Code, correct?
Yes.
And then it says it encloses the document of that order. Is that the same? Is this the same 2011 order that was from Missouri?
Yes.
That was entered in January 11th of 2011.
Yes, that's correct.
And based on this filing, can you tell me what date that reads?
This says November the 25th of 2019.
Okay, and then this date, are you able to see that?
Yes, I can see it. It says filed on November the 25th, 2019 at 7:51 a.m.
So same date's right here, right?
Yes, same date.
And from November 25th of 2019 up until March of 2020, did you have custody of Amari?
I had no possession, no.
So even after they said, hey, Texas, please recognize this Missouri order, the defendant did, you still didn't have possession.
I did not.
I'll pass the witness.
Defense?
Just briefly, Your Honor. Ms. Lee, you would agree with me, would you not, that the Tennessee courts would not rule on things once the Bexar County cases were filed because they needed more information about what was going on?
That's true.
Okay. And is there still pending litigation between you and Mr. TOUSSAINT,
Not in Tennessee, no.
anywhere?
Here in Texas, yes.
When was the last time you allowed your son contact with Mr. TOUSSAINT?
Your Honor, I'm going to object to the relevance.
Sustained.
Let me rephrase that. Are you court ordered to allow contact right now?
Yes.
Are you allowing it?
Judge, again, I'm going to object to the relevance.
Sustained.
And since the time period when you obtained Omari back, have you ever told Mr. TOUSSAINT not to contact you?
Your Honor, again, I'm going to object to the relevance.
Sustained.
I have nothing further, Judge.
All right, any further questions?
Happy further from the state.
All right, is this witness subject to recall or may she be excused?
We'd ask if she needs to.
Defense?
Subject to recall. Your Honor.
All right, the rule has been invoked. What that means is you can't discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state and the defense. Do you understand? All right, just make sure you're available in case you're needed for recall.
Yes.
All right, thank you. You can step down. All right, ladies and gentlemen, we are going to take a short recess. So we're going to come back at 3:30. I think that'll give everyone a chance for any breaks that they need. Remember, you've heard some evidence in this case, but you're not allowed to discuss it amongst yourselves or with anyone or begin deliberations. I'll let you know when you're allowed to do that. Does everyone understand? All right, thank you, everyone. Please rise for the jurors. I see everybody switching around, keeping me on my toes. Everyone, please be seated. All right, state, call your next witness.
Your Honor, at the time the state would rest.
All right, defense, you have a motion?
Yes, Your Honor, can I approach?
Yes. All right, defense, are you ready to proceed?
Yes, Your Honor.
All right, defense, call your witness.
The defense calls David Rodriguez to the stand.
If you can raise your right hand for me. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth so help you out?
I do.
You can lower your hand. State your name for the record, please.
David Rodriguez.
All right, defense.
Afternoon, Mr. Rodriguez. Can you tell the jury, what do you do for a living?
I'm a lawyer.
And what sorts of cases do you take?
I primarily handle family law cases here in San Jose County. I've been practicing for 9 years.
Where'd you go to law school?
I went to law school here at St. Mary's University in San Jose.
And before that, you went to college?
I got my undergrad degree from Texas A&M College Station.
And so, are you familiar with a person by the name of Otis TOUSSAINT?
Yes.
And how do you know Otis?
Otis is one of my former clients.
And you handled his case. You were his lawyer back in January of 2020, is that right?
Yes.
And you're familiar with the documents that have been filed in his case?
Yes.
Generally, can you tell us, Otis, what was his goal when he retained you?
Well, our goal was basically we got this appeals court ruling from Tennessee that essentially left the parties in limbo. They had a very vague order saying that to maintain a status quo, and that order was an appeal from several years prior. And so by this point, Otis and the child was living here in Texas, and so we were trying to get an order in place so that the parties would have something to follow.
So did Otis want to keep Omari from Sharita?
Absolutely not.
Did he just want orders so that there could be a framework to establish visitation for both sides?
Judge, I'm gonna object to speculation as far as the defendant's state of mind and his intent.
Sustained.
As his attorney, did you talk to him about what would be legitimate goals and the goals of the representation?
Yes.
Did he have, did you, well, and just again, tell the jury what those goals were.
Our goal was to get some orders in place that reflected the status of the parties at that time. The child had been living with Otis for 2 years, and everything was just kind of putting the limbo again with this rolling from the Tennessee appeals court.
So at some point in November of 2019, did you try to register the Missouri one?
Yes, and it was November, December of 2019. So if I could explain a little bit, basically, whenever a court makes order regarding a child, they have what's called continuing exclusive jurisdiction. And so the part of the transferring process is registering the order so that we can say that we're wanting to change the court from the prior court to the new court where the child lived.
So I'm gonna break up your testimony a little bit with some questions. Why register that order and not the Court of Appeals order? Why wouldn't you register the Court of Appeals opinion? Just tell the jury so they can.
Okay. So in these situations, we wouldn't register an appeals order. Basically, we're registering the order that we were looking to modify. And so at that time, the appeals court in Tennessee had vacated a prior agreed order that the parties had. And so because that order had been vacated, we had to register the order we were modifying would be the Missouri order. However, at that time, the Tennessee appeals court order, when they said maintain the status quo, that was the actual controlling order, the temporary order.
Okay.
That had been put in place.
So at the time, was the Missouri order in November of 2020 all the way, I guess, let's say through until March of 2020, November of 2019, I apologize, March of 2019. I'm going to start another question, Judge. From November of 2019 to March of 2020, was the Missouri order the controlling order?
No, it's not. That was not the controlling order.
Okay. What was the controlling order?
At that point, it was the judgment from I believe it was October of 2019 from the Tennessee appeals court where they said, basically we're going to maintain the status quo until we're able to get to, I think at that time they were sending the case to Shelby County, Tennessee.
So the status quo. So have you seen opinions in the courts of appeals where the Court of Appeals will say, you gave possession to dad, but mom should have possession, or you gave possession to mom and dad should have possession? Have you seen courts of appeals do that?
Yes.
Did the Court of Appeals change the possession from dad to mom?
No, that's the issue, that they didn't change the possession. They didn't say to go back to this Missouri order. They said, let's maintain the status quo because they had changed. I believe the Missouri order at that time was like 10 years old. Things had changed drastically. And so they said just to maintain the status quo. They didn't say return the child's mom or go back to Missouri order, which they could have done.
So did Otis ever ask you, did he ever say, Mr. Rodriguez, what should I do here? Did he ever ask you about giving the child back to mom? Did he ever ask you about that?
Yes.
Okay. And specifically, did you get a call? Every lawyer loves this. Did you get a call in the middle of the night asking you this question?
Yes.
Okay. And where were you in the middle of the night?
It was around New Year's. We had gone to my wife and I took our 2 kids to Ritos, New Mexico it was our anniversary. It was our anniversary on January 3rd. So we went, I believe, New Year's Day. So we were on vacation at the time.
So you're on vacation in Ruidoso, and Otis gives you a call, is that right?
Yes.
Okay, Otis calls you and he says, the police are at my door, what do I do?
Yes.
Something like that, right?
Yes.
Okay. And did you give him legal advice?
Yes, I did.
Okay. What was your legal advice?
Your Honor, at this point, I'm going to object to hearsay.
Sustained,
Judge, he is testifying about what he said.
sustained.
Can I approach her?
For what purpose?
For explaining.
No, the objection has been sustained.
So you did give him legal advice, correct?
Yes.
And did you tell him to give the children back? Or
Your
the child
Honor,
back?
I'm gonna object. This answer calls for hearsay.
Sustained.
No, this isn't hearsay. He's testifying.
The objection has been sustained.
Did you call the police that night yourself?
I believe there's some calls back and forth from the police, or actually, I called them.
Okay. And did you explain to them why it was your opinion that Otis should not give the child back?
Yes, I called and explained to them because at the time they only had Sharita's side of the story, so I wanted to make sure that they had a full picture of what was going on. So it was much more complicated than simply waiting a court order. There's several states at play at that point, there were several orders at play. And so we're trying to explain the entire, the state of things at that point.
So are you familiar with a list of acronyms, the UCCJEA?
Yes,
Are you familiar with that? Okay. Can you tell the jury what is the UCCJEA?
the UCCJEA is the Uniform Child Custody and Enforcement Act. And so that's an act that all the states are part of so that there's uniform rules regarding jurisdictional issues.
So when you have an out-of-state order, how is it that that order can become valid in Texas? Can you explain that process to the jury?
Well, to make an order, what we call it, it's called a foreign order, even though it's just out of state, it's not from the country, but it's described as a foreign order. Basically, we've got to, depending on the purpose, register it here in the county or the state wherever you're trying to have it used.
Okay. And so when you register it, is it automatically valid in that state?
No, it's not.
Okay. What has to happen to make it valid in that state?
There's a process that has to go. We file the notice to register it, then notice has to be sent to the other party, let them know that the order is going to be registered, and give them a chance to object to it.
So did you try to register that Missouri order?
Yes.
Okay. And that was in November of 2019, is that right?
Yes.
When did that order become effective in Texas? Approximately.
I don't know that it ever became effective. In Texas.
Okay. When did that use, and so the UCCJEA, it requires, tell the jury what it requires to make the judgment that you're trying to register effective. Tell the jury what that requires.
Well, so basically, whenever there's again, there's a court of continuing exclusive jurisdiction. That's the court where the original orders were done, or the prior orders. In this case, we were trying to, at this point, we're trying to get the case moved to Texas because that's where the child had lived for 6 months. And that's one of the requirements, is that the child has to live in the state for 6 months before you can get the order there. And so what happens is the courts, in this case, Bexar County Court and a court from Tennessee, we had to have a UCCJ conference with both judges and all the lawyers there to determine which court should have jurisdiction.
When did that conference take place?
The conference happened in June of 2020.
And so, and by that point, Omari was now living with Sharita, correct?
At that point, I believe the child was still with us.
And there may have been prior testimony that she retrieved the child back in March of 2020. Do you have specific recollection exactly when Omari came back?
Well, so in March, Sharita tried to she filed something in Tennessee saying that, again, with the Missouri order saying that Otis was supposed to have possession. The Tennessee attorneys had to go and challenge that, and the judge in Tennessee ordered the child be returned to Otis. And that was in March of 2020.
And so finally, in June of 2020, the UCCJEA conference took place, and that's when the order modified and now the case is in Texas, correct?
No, at that point, what happened is we had the conference, and again, there's 4 or 5 attorneys, 2 judges, and we're still pretty much unable to come up with what's the correct, who has jurisdiction in this case, because the child hadn't lived in Tennessee for almost 2 years. They've been living in Germany. He had been in Texas for over 6 months at that point. But the court here found that the case in Tennessee was still pending. So at that point, it was going to be sent to Tennessee so that Tennessee could determine whether or not they wanted to have jurisdiction, because they could decide that they weren't the appropriate form and they could send it back to Texas.
Let's go back to January of 2020. Did Otis intend to violate any valid court order?
Your Honor, I'm going to object to speculation.
Sustained,
Judge, this is the exact question that you allowed a police officer.
sustained,
Did Otis knowingly violate a valid court order?
Your Honor, same objection to speculation.
sustained,
Did you have conversations with Mr. Toussaint about this, about the court orders?
Yes.
And after those conversations, did you know his state of mind?
Yes.
Did he have the intent to violate a valid court order?
Your Honor, again, it's speculation.
sustained,
Your Honor, it's what he knows from his.
Sustained.
firsthand. Did Otis Toussaint violate a valid court order on January 2nd of 2020?
Your Honor, I'm going to object to call for an ultimate issue and invades the province of the jury.
sustained,
You have allowed a police officer to testify. to the same
Sustained.
question, Your Honor.
and for the record, no officer testified to any legal conclusions. The objection from the state will be sustained.
And just once again, what was the controlling order on January 2nd, 2020?
I believe the controlling order at that time would have been that the judgment from the Tennessee Appeals Court, where they ordered the parties to maintain status quo.
And at that time, when the Tennessee Court of Appeals made its ruling, Omari was living with Otis, correct?
Yes.
And so I have no further questions, Ron. I'll pass it.
State,
Thank you, Your Honor. So, Mr. Rodriguez, it's fair to say that you represented Mr. Toussaint during this period of time around January 1st, 2nd, and 3rd of 2020.
Yes.
And so, in your conversations with Mr. Toussaint, did he tell you that police were at his residence
When?
around January 1st, 2nd, or 3rd of 2020?
I believe so.
So he told you that police had come to his house.
I believe so.
Did you have conversations with him prior to you contacting the Summit Police Department?
Yes.
What did he tell you about it?
What did you?
What did he tell you about you contacting the Summer Police Department?
Was it Otis?
Yes.
I'm not understanding.
Go back to the form of the question, Your Honor.
All right, that'll be overruled.
Did Otis tell you to call the Summer Police Department?
No.
So you just did it on your own?
Yes.
And how did you even know to call the Summer Police Department?
From my conversation with Otis.
Okay, so in that conversation, did he tell you, hey, someone's trying to get a hold of me?
I don't know if they said a specific thing that they're trying to get a hold of.
Okay, what did he tell you about? What did he tell you about police coming to his house, and why did you contact the police department?
I don't remember exactly what he told me, but I believe I had to report I don't remember exactly what he said.
Okay, so why would you call the Summer Police Department?
Because I wanted to explain to them basically where we were at in the process and that we were trying to get everybody. I was trying to explain to them that one, they didn't have the full story, that they didn't, that Sharita wasn't telling them everything that was going on, and I wanted to tell them that we were trying what we're trying to do, because of what the Tennessee appeals court order left us with basically nothing, is that we're trying to get some orders in place so that the parties can follow and that they know what they're supposed to do.
Let's talk about that. So it's your testimony today that it is your legal opinion that the status quo is the controlling order.
The order from Tennessee saying they're maintaining the status quo.
Okay, what does that mean?
It's very ambiguous, and that's the whole reason why we're trying to get some orders in place.
You agree, as an attorney, you have an obligation under the canons that be pleaded with the court, correct?
Can you repeat that?
As a licensed attorney in the state of Texas and under the state canons, and with the state bar, and the rules of the state bar, you have an obligation to be candid with the court.
Yes.
So I'm going to show you what's been admitted as State's Exhibit number 5. Office of David Rodriguez, that's you, right? Okay. And in this, you're asking Air County to, it's a formal request to register an order under the Uniform Child Custody Jurisdiction Enforcement Act of the Texas Family Code, correct?
Yes.
And so in that, you are saying that there is an order in place and I want Bexar County to recognize it.
What do you mean by in place?
So if you are going to register an order, you're going to register an order that has been entered, correct?
Yes, so what we're doing is we're registering the last final order, but there can be other types of orders.
Okay, so you can just register whatever order you want.
No, we can register final order.
So it's the last final order. Okay. So that's not the status quo, right? That's the Missouri order, right? You're not registering a status quo as the last final order, right?
Right, that wasn't a final order, that was just like an interim or temporary order from the Tennessee appeals court.
Okay. So why don't you try to enter the status quo as a enforceable order?
Well, because it's not enforceable today, that's the issue is that we're registering the order that we're trying to modify. We're not trying to modify the judgment from the Supreme Court or the appeals court.
And to that point, if you're trying to modify it, you're saying that it was in place, it was in order, we're just trying to modify portions of it, correct?
What we're saying is that that was the last final order after the Tennessee order had been vacated, but I'm not saying that there's not any other temporary orders, no other orders out there. That's the final order, basically.
Okay, so you're asking Bexar County to enforce it, right?
No, we're asking them on
That misstates the testimony.
So
Overall,
what are you asking Bexar County to do?
we're filing a modification to modify the prior final order.
But you're asking them to recognize it, correct?
Yes.
So you see how that really doesn't make any sense. If you're asking to recognize it, but it's not the valid order in place.
It's so it's I'm just gonna explain it. So basically, this Missouri order was the last final order. Whenever we have an order, like let's simplify it on a simple order in Bexar County. Let's say you got divorced and you have child custody issues. The divorce is the last final order. You can file a petition to modify, like we did in this case, and the court can enter temporary orders that change the prior order, but that prior order still remains the last final order. And so we're asking the court at that point that we want this order modified, but we're not saying that the Tennessee order to maintain the status quo is not in effect.
So you're saying basically there's 2 orders in effect?
Well, and at that point, myself and other lawyers and judges, and in fact, in this case, all disagreed on what the actual status was, and that was the point of the conference and trying to figure out. And that's what we're trying to do. We're trying to get something in place so that everyone knew what they were supposed to be doing and when. And so at that point, there was nothing. The appeals court order for Tennessee basically left it with some ambiguous vague language, maintaining the status quo. What does that mean? No, I mean, it can mean whatever you want.
So just so I'm understanding, what you're saying is that it's your legal opinion, and obviously you have a bias, is it fair to say that, because you represented Mr. Toussaint?
As far as on the what? My
You're-
legal opinion
You're gonna,
bias?
you're gonna litigate and you're gonna be arguing on his behalf, and you obviously have his interest in mind, not necessarily Sharita's, right?
Yes, when I'm representing the client, I have their interest in mind, and that's the number one thing.
And so it's your opinion that status quo is the current order that was in place. As of March, I'm sorry, as of January 1st, I'm sorry, 2nd of 2020.
Which, what do you mean by current order?
The valid order as of March, I'm sorry, I keep saying the wrong month, as of January 2nd of 2020, is your legal opinion that the status quo is the order, the valid order in place,
On January 14th.
2nd of 2020.
On January 2nd? At that point, the order, controlling order would have been this judgment, that's like, it's not even half a page judgment from the Tennessee Appeals Court that just says, and in their opinion, they say, look, the child lived with dad, or whatever, and then at the end, they just say it's ordered to maintain the status quo until it goes to Shelby County. So at that point, that half page would be what's controlling.
And you've read the opinion, correct?
Yes.
Okay, let's go over some portions of the opinion. Says, we're starting here, on remand and after transfer to an appropriate Shelby County court, mother and father can file any such motion she or he may deem necessary to address any issues in the custody proceeding related to the father's petition to domesticate a foreign decree and to modify custody of the child, correct?
If that's what it says?
I'm reading that correctly, right?
Yeah, that's what it says.
Okay, and so how in the world can you modify an order that's going to be domesticated if no order exists? If the status quo is what the valid current order is as it relates to the possession of Omari.
Can you put that order back up?
Yeah, absolutely. And starting, I was reading starting right here on.
Yeah, and so the issue is that when it's talking about in this last line where it says father's petition to domesticate a foreign decree and modify, that's referring to a petition to domesticate and modify that was filed by father in Tennessee back in 2016. That's not referring, this is before when I'm involved, so they're not referring to my petition, they're referring to a prior petition. So the Missouri order was my understanding was attempted to be domesticated in Tennessee. They're not referring to anything we're doing.
And so this opinion from the Tennessee Court of Appeals is in part, and by reference, recognizing that the Missouri court order is still in place, because if it wasn't in place, how in the world could you modify it?
I don't know if they recognize it.
That just doesn't make plain sense to you,
What part?
that you can't modify something that's not enforceable and currently valid.
That you can't. I'm sorry, I don't understand.
Can you modify an order that's not currently valid? So how in the world could they modify an order and this court say, we're gonna go, the father petition to domesticate, decree, define, let me go back. Mother and father can file any such motion she or he may deem necessary to address any issues in the custody proceeding relating to the petition to domesticate a foreign decree and to modify custody of the child. How could they modify, with this court recognizing an order that's in place, an order that's not valid? Does that make sense?
How could they modify an order that's not valid?
Right, so how could it be possible to say this Missouri order is not valid, but this court is saying the mother and father can go litigate the domestication of that order to modify it?
It's the same thing that I was explaining to you earlier. Basically is that just because that's the last final order doesn't mean that that's the order enforceable at that time. That's the last final order that's gonna be modified. And that's what their agreement was. They had agreed to modify that order. And so the appeals court didn't invalidate the party's agreement that the child was grabbed. It just invalidated the actual order itself,
Invalidated which order?
the Tennessee order.
So we can agree at least on that. 2017 order is no longer in effect, right?
Right.
Okay. As of this 2019 opinion.
Yes.
And so is it fair to say that at that time, the Missouri order was still in effect?
After this opinion?
Yes.
No, because they said, no, they're saying that they're wanting to maintain the status quo.
Okay, but I
Like the
understand.
court would have said, send that if the Missouri order is in effect, the child should go along with mom at this time, go back to mom or follow that order. They just say, maintain the status quo, the child been with that for 2 years.
I know you're hanging your hat on the status quo, but I want you to look up. And the rest of the opinion is important to understand the conclusion, right? Because that's the whole point of writing an opinion on a case.
Well, the opinion, my understanding is the reason that they vacated that order was because in Tennessee, they have a requirement after an order is entered that you have to mail it to the parties. It's called a certificate of service.
And Mr. Rodriguez, I'm not asking about the litigation.
I'd ask that you be allowed to answer the question.
That'll be overruled.
Mr. Rodriguez, I'm not asking about why the 2017 order was invalidated. This court tells us why. I'm asking that in general, I hope we can agree that on appellate decisions, when we get an opinion from a court of appeals, it's important to read the entire opinion to understand exactly what the court's ruling is, right?
In what context?
In any context.
So it's important to read the opinion?
Yes.
Yes.
Okay, that's a pretty simple answer. And in this, part of that opinion is that line I keep reading over and over again, that it talks about domesticating a foreign decree and to modify it, and that the mother and father can go back in Shelby County or whatever county it is, Shelby County, and litigate the modification of that order.
If they can litigate the modification of the Missouri order?
Yes.
I think at this time, what they're saying is, if you read the whole opinion, is what they're saying is that that was filed in Tennessee at some point, but that had never been finalized, and so.
You would agree that in filings in cases that you have represented, Mr. Toussaint on, you have stated that the Missouri order is the controlling order, correct?
Yes, it's the order that we're seeking to modify.
That's not my question. My question to you is, in your filings, in your representation of Mr. Toussaint, you have in writing to the court have stated that the Missouri order is the controlling order, correct?
Yes, that's the controlling order that we're seeking to modify, but not saying that that's the controlling order that controls the possession access at this point.
Okay.
It was a complicated case. I mean, like I said, many lawyers disagree on what.
I mean, obviously you do, but not everyone, it's fair to say,
Many,
right?
many.
And ultimately, you have this order domesticated here, right?
I don't know that it was actually finally domesticated here, but I did file the notice to do that, to start the process.
Okay. Were you no longer representing Mr. Toussaint at the time it was finally domesticated?
I don't know if it was ever finally domesticated.
Okay. As far as your awareness and knowledge of the cases and further proceedings here in Bear County, up until what point do you have knowledge of it, of the case, time-wise?
Approximately June of 2020, whenever we had the conference with the court.
Okay, so after that, you haven't really been involved in the case.
Correct.
Mr. Rodriguez, what's the next parte order?
That's an order that you go to the court without the other side being there.
So like one party's not there, correct?
Yes.
I'm showing you on page 3 of this opinion, where it says, as a consequence of father's petition, the juvenile court entered an ex parte order and attachment ordering the return of the child to father's custody immediately. The juvenile court also ordered that mother return the child's passport to father. Is it fair to say those are ex parte orders?
Well, the first one, it said again, it's a little bit different. Obviously, it's in another state, but typically whenever you're filing a habeas proceeding, it's done ex parte. That's the procedure. I don't know if the second part was done ex parte or not. I don't know.
So at least the portion that we can agree on ex parte, that was done without without Sharita being present necessarily.
That's what it would mean. I don't know. What was there.
So when you go and you domesticate the foreign order, and let's say just hypothetically, I have an order, a final order in place in Louisiana. And I take that order and I bring it to Texas and I file to domesticate it. Does it mean that that order that I brought over is not a valid order anymore?
No.
Just the mere fact of asking a court to domesticate it does not put everything on hold, right?
What do you mean by that?
It doesn't put that order on hold, and you just get to do whatever you're gonna do until a court in Texas decides what to do.
When it's after it's domesticated,
No, just in filing the domestication,
and filing it, they will put everything on hold now.
right? That just makes logical sense, right? So the point of the domestication, right, when I'm gonna take an order to Texas, is I'm saying, Texas, I want you to either enforce this or recognize it so that I can modify it, right?
The point is to give the court jurisdiction. The jurisdiction prior to the registering is in the other state, so you're trying to bring the jurisdiction over to the state that you're registering over the child.
So it doesn't change the validity of an order, it just changes which court can hear it, right?
Yes.
So when you went to domesticate the 2011 Missouri order, you weren't telling Texas, hey, this is, I'm asking that this, show that. So when you take this model for the domestication of the 2011 order, you're asking Texas to say, Texas, I want you to hear this case. This is the order I want you to hear, right?
We're not asking them to hear the order, we're asking the court, basically, we're asking to get jurisdiction over the child so that we can modify the order.
Okay.
So that's what we filed a petition to modify the out state order.
So you're asking Texas to recognize it, right?
Yes,
Okay, and you're asking, in this case, you're asking Texas to recognize it so that you can modify it.
yes,
So you're asking Texas to enforce this order.
no.
You're asking Texas to at least recognize this order, right?
Yeah, yes,
It's a
basically, we're
pretty
asking,
simple answer, right?
what was that?
You're just asking Texas to recognize it, right?
Yes.
And you're maybe approaching.
Yes. This case, but you're not allowed to discuss it amongst yourselves or internally. Do you all understand? All right, everyone, please rise for the jurors. right, everyone, please be seated. Ah, okay. State,
Yes, Your Honor. Mr. Rodriguez, during the break, you're able to listen to a recording, correct? And in that recording, it contains your voice. Is that fair to say?
Yes,
And is that recording in part document by video and audio your conversation with Summer Police Department on January 2nd, 2020?
it documents one of the conversations. I had several with them. I don't know which one it was.
But at least one of them, right?
Yes.
Your Honor, at this time, state will move to admit State's Exhibit number 13.
A prior note of objection.
all right, State's Exhibit number 13 is admitted.
Your Honor, may I publish the jury?
Yes.
Oh, okay. Yes, sir. Did you have some questions? Is- Correct. But there was a child custody agreement that was acknowledged by him that she provided. Based off of that, we contacted the DA in Bear County. And they said to go ahead and follow charges based off that decree. So we're gonna file charges with interfering with child custody. It's scanned into the report. So
Never know what it is, because, like, so basically what's going on is, they had some order like that, I think in 2010 back in Missouri, they had some other order.
Tennessee.
In Tennessee, and then we have a case pending in Bear County. Basically, right now, this is going on in Tennessee and in Texas. And, I just want to know what order that's going off of that she's giving you, so that I can point that in the right direction, because, yeah, even if it's going off some order that they had from Missouri, if you read the order itself, which, again, that's not even, I don't know what state this case is in, because there's been a deal and back and forth. Basically, even if you go look at that Missouri order and read the language, today is his time, like, he gets New Year's right now, so it's not, you guys are violating the order.
So what year does she get it? What year? Because she hasn't seen her son in a year.
Oh, well, no, the son has lived with Otis for like 3 years.
Correct. So what time would she get it in that time frame? I don't understand.
She, in the summers, like she got there in the summers. So what happened is they had some,
So she told me she hadn't seen her kid in a year.
no, that's not true. And so basically they had this Missouri order way back when where the child lived with her. And then they moved to Tennessee, they entered this other agreement where the child moved with Otis to Germany, because he's in the military, moved with him to Germany.
Does he have that agreement written down by the court?
Yeah, okay, so yeah, it was a court order, and I can, if you send your, if you give me an email address, I can forward you all these documents, but.
Okay,
So,
what?
okay, hold on, let me explain it first, please. So basically, they had this agreement going on, in Tennessee for a while, and then later on, she appealed it, and that agreement, because of, for whatever reason, was, that agreed order was, drawn out. So now there's like basically, that order is not in place, the custody battle is still, they're still going to court on that issue in Tennessee. The child has lived in Selma for over 6 months, and so we filed to transfer the case to Texas. And, so it's still pending, but she's been seeing the kid for all this time, he's not withholding it. I mean, if she's saying that it's a Missouri order, I don't know what she's telling you, but even if you go read that order, then that would be his time, so he's not violating anything.
Custody order, she's supposed to have a New Year's Day. We had New Year's Eve.
Okay. I'll be honest with you, Mr. Rodriguez, we're going back and forth with this information. He didn't answer the phone at the door.
Report here that you can, New Year's Eve and odd number years, which New Year's Eve is would be 2019, and New Year's Day But if you read it, it says plaintiff, which was held, shall have New Year's Eve, on New Year's Day, even meaning the 19 to 20 transition.
Okay,
And it doesn't even say what's supposed to, like that order doesn't say anything.
are you a civil attorney or a criminal attorney?
I suppose.
You do both. This is what's gonna happen. We're still gonna file it and then it's gonna go to CI.
It's just that we're filing charges against the guy, but, and then there's like other implications, like I'm telling the guy like in the military, stuff like that, he's not violating.
He didn't answer the door and he keep a child from their mother,
What's investigating?
investigating, interfering with child custody.
When you're looking at the order, how can you be interfering if it says a
Anytime there's an allegation of a criminal offense, we conduct a report and forward it to investigation. That's where I'm at on that, and I find there's enough evidence on there
okay,
to.
contact the tomorrow, or what's the
Yes,
best way, what's their contact?
The CID, you contact our, I don't know who's gonna have the case tomorrow.
What's the number of the CID?
Here, I got you right here. It's gonna be, our office number is 210-651-5368.
Sure, it's the right.
Reports on this one, we had to file it.
I mean, but it's not like, if he's not violating the orders, there's no interference, there's a big premise.
Correct, but if I have suspicion that a crime occurred, I'm gonna take a report, whether that be interfering, theft, or regardless, I have to take it.
Okay, so the right contact CID tomorrow, and I can send them all the information.
Correct.
Does he have the order with him?
He has an order with him.
I can email you everything.
You have your email address? Yes, it's you.
What's his name?
It's Rodriguez.
Mr. Rodriguez, I'm the investigating officer, I'm Officer Lopez. I'm the one that actually got the call for this. So let me ask you this, do you have the actual order in hand with you, the child custody order?
Well, I have it on electronically, yes, but.
Yeah, okay, that's fine. So
Call me, hang out there, yeah.
when is he supposed to return the child to her? Let me ask you that.
The order doesn't say, and this is kind of order, and like, so a lot of cases orders have specific dates and times. But if you look at that order, it doesn't say anything about anything.
But it says what days he's supposed to have them, right? You said it shows what days, which you said New Year's Eve, right? Is what it says. on the order?
New Year's Eve and New Year's Day, yeah, so it's-
I have to read it again, but I'm pretty sure I saw only New Year's Eve.
well, if you read, yeah, I mean, if you look at it again, it's confusing, but it says New Year's Eve, and then it says New Year's Day.
Okay, so the way, I know it's very different from Texas, but the thing is that we have to follow what the judge says. So if it says New Year's Eve, that's fine. But the thing is, that today's New Year's Day, I didn't see that on there. So is he willing to return the child anytime soon, or what is his plans?
Like what month, what day, what year?
Because she's saying that he has never returned the child for a year now, and let's just say that has happened, that's fine, okay. But our main concern is to get the child back to the person that he's supposed to be with. So is he supposed to give the child back today or tomorrow? Is that his plan, or is he just gonna keep the child until the court finds out what they want to do?
Pending the court order there in Tennessee. So basically, this case is going on in Tennessee. This order that he's talking about is Missouri order.
Right, but so this is the thing, who's supposed to have the child during that time?
They don't have, I don't know, that's the whole thing we're trying to figure
Yeah,
out.
that's not gonna work with
Yeah.
their county.
That's the thing, and in Bear County, they're gonna
That's a criminal offense.
go off.
But even then, the order doesn't say anything about having an offense. What if you violate that order?
So the mom doesn't get to see her child for years? That's not gonna fly.
That's not true, though. Okay, so let me send you order and something if they agreed, it was something that they agreed to, when I think the child will build it with the leader.
Okay, they agreed in writing or in verbal?
It was an order, it was an agreed order.
I don't have that. You don't have
Okay.
it?
But it's still, it's completely civil, and if you look at the order itself, he's not violating, so.
Mhm.
I mean, look at the order, I mean, when did he propose it? You're exactly right, it doesn't say anything. That order, they had another order in place, for years, that was just thrown out in Tennessee, they're still going, it's ongoing court hearings over that order.
Yeah, and that's the thing that this is the first I hear about that second order. So like I asked her, I said, ma'am, I need you to be able to straight up, and I need you to tell me if there's any other orders from any other state, because I know they live in different places. So how about we do this? Just send me those orders to my email. You got a pen? It's CLOPEZ@ci.selma.tx.us.
Okay, so C Lopez at ci.selma.tx.us.
Yes, sir.
Okay, and then, and you said it was your Sergeant Lopez?
No, I'm officer, the sergeant. Pence is the one you were talking to in the first. At first.
Okay, so Sergeant and,
Me, I'm Sergeant Pettis. My badge number is 1327.
and you're the supervisor?
Yes, sir.
And then, so would you, Officer Lopez, you would be the CID person I'll be talking to?
No, sir, I'm the investigating officer. From here, what I do is I
Patrolman.
yes, I put it together and then I turn over to CID.
So anything you provide will attach to this case and send it forward.
I mean, all right, I'm trying to, I'm gonna start working stuff here. I'm on vacation, but I wanted to call and,
Yeah.
talk to you, and I'll probably call you tomorrow, right?
Yes, sir. We're only working until 6 in the morning, so after that, you'll talk to a different shift.
Okay, all right, thank you for your time.
No problem. Have a good day.
Hey, Mr. Rodriguez, during that phone conversation, you would agree with me that multiple times you tell him, them, both of the officers on the other line of the phone, that how can you violate the order, right? And the order you're referring to is the 2011 Missouri order.
How can you violate the order?
Right, you said that multiple times, correct?
Yes.
And in that, you even talk about specific dates in that order and specific provisions in that order, especially as it relates to New Year's Day, correct, and New Year's Eve.
Yeah, so I was trying to, well, one, listening to it again, I realized they kept cutting me off. They didn't let me explain that that wasn't the court order, but I told them even if, which is saying that's not what I believe is the controlling order, even if it's the order that you're relying on, the only half of the story that she provided, then even then, he wouldn't be violating the order.
Did you ever use the word status quo during that conversation with them?
I'm not sure, a lot of it was cut off.
Okay. And
I sent them, I was trying to send them all the things, all the orders. The officer said that, it's like, I don't have everything, I don't have the Tennessee stuff, so I was like, look, let me send you everything so that you get a full picture.
correct me if I'm wrong, in anything that the jury just listened to, did you ever use the word status quo?
What they, and what, from this video?
Yes, no, right?
No.
And in it, you talk about specific provisions of the order to include specifically number 14, when you explain to the officers, look, under this order, he's supposed to have the kid, right? He can't violate the order because he's supposed to have Omari on New Year's Eve and New Year's Day.
Yeah, I was explaining to them that even with what they have, which I didn't believe was a controlling order, I was trying to explain to them, even if you look at what you have, he wouldn't be violating. So he wouldn't be violating both orders. It wasn't, I wasn't telling them that the Missouri order was controlling them. I was telling them under both orders, he's not violating.
Under what other order would he being out violated?
Under the judgment order from the Tennessee Appeals Court.
Did you ever mention that to them?
You can go back, I did, I said, there's an appeals court, it's pending, I said, I'm gonna send you it, and they're like cutting me off. He wouldn't let me finish explaining to him how, this is an extraordinary case, it involves 3 states, it's not typical.
Maybe your recollection is a little different than mine, but what you said is there was an appeals in Tennessee, and they threw that other order out, right?
Yes, and I said, it's still pending, it's still being litigated.
So they threw out the 2017 order, right?
Yes,
And
they
the
did.
only other order that you talk about is the Missouri order.
No, I said, I tried to tell him, look at the Tennessee order, in place. You can go back. I told him.
Okay, well, the jury will have it, to make them listen to it. So when you were also talking about the Missouri order, you said, well, when they asked you, well, when is mom supposed to have, mom being Sharita, when is mom supposed to have the kid? And your response is during the summer, right?
I don't know if that's exactly, I think I was referring to the, under the Tennessee order, which we had the summers. And that's what they had been going off of previous, like, before that point, they were going off the Tennessee order, so that's what you had to tell them.
And even after you filed to domesticate the order on November 25th of 2019, you could agree that it's about a month and a half later, maybe a little bit less, you're telling the police officers in this case, and you're only talking to them about the 2011 as it relates to specifics about the order.
I'm calling them, I'm calling to explain the situation to them. I was telling them that, I was trying to tell them that Missouri order wasn't the controlling order, that's why I asked them, I was like, well, what did Sharita give you? What do you have in front of you? Because I wasn't.
Did you ever tell them that the 2011 Missouri order was not controlling?
I believe so.
Okay, what words did you use? Because I didn't hear it.
I'm not sure. I mean, in my conversation with them, I told them that wasn't the controlling order. This is only one phone call. I talked to them several times that evening. I think this one was at 2 a.m. I may have talked to them before or after.
And I'm talking
the next
about,
day.
I'm sorry, and I didn't mean to interrupt, Judge, I'm sorry. I'm sorry, Brenna. I'm talking about this recording. In any part of this recording, did you tell them the 2011 Missouri order is not controlling?
I believe so. I don't know. I have to listen to it. I mean, if whatever I was trying to explain to them that it wasn't controlling. I don't know if I said specifically that's not controlling, but I know I was trying to explain that it wasn't controlling.
So when you listened to it just now, that was the second time you listened to it, right?
Yes.
Okay. So you still don't know if you didn't tell them that the 2011 Missouri order was not controlled?
I don't think I told them that specifically. What I told them, what I was trying to explain to them was that it wasn't the controlling order.
And when you're talking with the officer in this case, they ask you, well, when is mom going to have possession of the child? And they ask you specifically day, month, or year, right? You remember that question?
Yes.
And you didn't provide an answer to that question, right?
There's not an answer. That's what we're trying to figure out. We're trying to get an order in place so that we know those answers. And so at that point, there wasn't an answer. That's what we're trying to figure out.
So it's your legal opinion that Mr. TOUSSAINT can have this child from October 15th of 2018 until March of 2020. And that would be compatible with the current order that's in place. Without Sharita ever having possession of the child during that period of time.
What order are you referring to?
What you would consider the controlling order.
Well, they think at what point? On January 2nd, when we get called, or what point?
My question is, from October 15th of 2018, when Mr. TOUSSAINT took Omari to Germany from school in Tennessee, up until when Sharita testified, up until March of 2020, when she got Omari back. She testified the fact that she did not have possession of the child at any period at that time. So, is it your legal opinion that during this period of time, again, October 15th, 2018 until March of 2020, whatever legal order you think is in place, whatever controlling order is in place, during any period of time, she was not allowed to have possession of the child.
If an order said she wasn't allowed to have possession at that time? I'm not understanding your question.
My question is, isn't it true that during the periods of March, as of October 15th of 2018, up until March of 2020, there should have been at least some period of time that Sharita had possession of the child?
That's what we were trying to get to, and so we're trying to get an order in place so that we could establish the visitation. But before that, until October, there was the court order in place with the Tennessee order. Whether or not she saw the kid before, it's my understanding she would see the child in the summer, and she would keep the child, and that's how this whole appeal started. It was from an enforcement action where she didn't return the child. Always had to get the ex parte order. The judge ordered the child to be returned to dad, and then that's whenever they're repealing that, they went back and looked at the modification order.
That's a lot of an answer that doesn't answer my question. My question to you is, she testified to that fact from October 15th of 2018 to March of 2020. Is it your opinion that there was no legal enforceable order in place that would allow her to see her child during that period of time?
Your Honor, this has been asked and answered.
That'll be overruled.
That's not my opinion.
So is it your opinion that during some period of time, she should have been able to see her kid? Have possession of her
Whatever
child?
the order says, I don't know what it says.
The Tennessee order that went in place in 2017.
Yes, whatever the Tennessee order said, then that was the controlling order until October of 2019.
So let's change the date, October 2019 to March of 2020. Is there any period of time that she should have had possession of that child?
And I don't know that answer, and that's what we're trying to figure out, is that we're trying to establish a court order in place. The Tennessee appeals court ruling really threw a wrench in everything. This isn't a typical case. When they threw set aside a 2-year-old order and basically left nothing for us to go on. So there wasn't, the only thing we had at that point was that to maintain the status quo, and that's why we filed the case here in Bexar County so that we could get something established.
So this 2019 opinion came down. That, in your opinion, essentially invalidated the 2011 Missouri order. It was not enforceable.
It didn't invalidate it. It wasn't in effect at that. It wasn't in effect at that time. So it wasn't in effect at that point.
And again, this order that was not in effect, you asked Texas to enter it and to recognize it, correct?
Yeah, we're trying to transfer the jurisdiction so that we can modify it.
So some court had jurisdiction over it,
At that point, the Tennessee had jurisdiction
over that order.
over the child.
And there was a pending case, right?
And on what date?
On March 2nd, I'm sorry, of January 2nd of 2020.
On January 2nd of 2020, so this order came out. I have to give you some of the background because it's so complicated. But basically, the order came out in October of 2019, the appeals court judgment. At that point, the child and Otis were no longer living in Tennessee. And so at that point, the child had been in Texas for 6 months, or approximately 6 months. And so the case by Otis in Tennessee was not suited in December.
Really doesn't answer any of my question. My question is that on January 2nd of 2020, let me go back. On November 25th of 2019, when you tried to domesticate a foreign order, specifically the 2011 Missouri order, you said that there was continuing jurisdiction, so a court had jurisdiction, correct?
It was determined that Tennessee had jurisdiction.
So a court had jurisdiction, that's my question, to be a yes or no.
Yes, the Tennessee court.
And they had jurisdiction over the case, correct?
Tennessee had jurisdiction over the case, yes.
And that case was to modify the 2011 Missouri order.
in November, you're talking about on November 25th of 2019?
Yes.
Yes, I believe so.
I'll pass the witness.
Defense?
Thank you. Let's talk a little bit about, as a lawyer, when you give legal advice, you always tell people what they want to hear.
No,
If, and Otis, he was following your legal advice on January 2nd, 2020.
right.
And your legal advice, you had, so just because you have a relationship with a client, doesn't mean that you tell them what you think they want, correct?
Correct.
And explain that to the jury. What's the job of a lawyer when you see something that, and sometimes, attorneys have to give bad news, and sometimes it's not what our clients want to hear. So explain that to the jury when that happens.
Yeah, I mean, basically the job as an attorney is to discuss whatever the issue the client's having and tell them what, based on your experience, what the likely outcome is going to be or what to expect or what the results can be. And it's not always what the client wants to hear. So, but as an attorney, you have to tell them sometimes what they don't want to hear.
And so, did you believe that your legal advice would lead to a criminal case against Otis? We're not turning over the child.
No, I don't.
And when you're talking to the police officers, obviously it's late at night, and as lawyers, we don't always have all of our files in our head constantly. Is that fair?
Yes.
Did you expect when you went on vacation that you'd get a call from Otis in the middle of the night asking you to call the Selma Police Department?
No.
So how many times did you call the Selma Police Department?
I don't know exactly. There were several calls that night and the next day. And
Did you record your part of the conversation with the Selma Police Department?
No.
Did they tell you, hey, we're recording this conversation?
No.
Did they tell you we're only recording one conversation?
No.
So there are conversations that this jury is just not going to get to see. Is that fair?
Yes.
But you were saying, and this is something that lawyers sometimes do, and we call it arguing in the alternative. Can you explain to the jury what arguing in the alternative means?
Yeah, I mean, basically, like I was saying, is I was trying to explain that even based on what he's relying on, which I didn't believe was correct, and I didn't believe was the full picture, I was trying to send him all the documents because there's an extensive procedural history from Tennessee, really. And so I knew they didn't have that in front of them because mom had tried to do this before, but so I was trying to explain to them kind of what was going on with the case, but I was telling them even based on what she's given them without me first giving them on our side, I'll say even then they're still not correct.
So I'm just going to show you something real quick, just to that point. I get this. I'm going to show you what's been marked as defendant's exhibit number 3. It's a public document. Do you recognize that document?
I believe so.
Is that the Judson ISD school calendar?
Yes.
When would school have started in January of 2020?
Your Honor, I'm going to have a check on the foundation that he has no personal knowledge. He's giving him a document basically asking him to read from it.
It's a public record, Your Honor, kept by.
Court hasn't seen the document. And State, have you seen the document?
I have not.
All right, is there gonna be any objections?
We would object to the foundation of this. It is no testimony that this is a public document. It have any authentication exception. He has no personal knowledge as far as the Judson ISD calendars.
All right, if parties can approach.
So when you have a child custody order that's not being followed, there are a couple of ways to enforce that. Is that right?
Yes,
One of them is to file an enforcement.
yes.
While you were representing Otis, did Sharita ever file an enforcement?
Not that I'm aware of.
The other way is to file a writ. Is that right?
Yes,
Okay, and you can get a writ of attachment.
yes.
To file an enforcement, you can actually put somebody in jail for violating a civil order. Is that right?
At this point, I don't object to leaving and flipping.
That'd be the same.
What are the consequences for violating a civil order?
Well, in consequence of violating a custody order, you can be held.
And Your Honor, at this point, I'm gonna object to the relevance of the civil implications of not following the child custody order.
This is relevant.
She didn't avail herself of the civil remedies.
All right, that'll be sustained.
Was the Missouri order specific enough to be the subject of an enforcement?
Not by Texas. I don't know about Missouri, but here in Texas, it would be enforced.
Okay, and explain to the jury why it would not be enforceable.
Well, it's a due process issue. You've got to have notice, and so that's what I was trying to explain to the officers. Is like the order didn't say anything as far as when, like where you're supposed to be at what time. Like here in Texas, the order would say on the first, third, and fifth Friday of each month at 6 p.m. You're going to go to the other person's house to pick up the children. If you're not there at 6 p.m. To pick up the children, or the other person doesn't release them, then you could be in violation. The Missouri order wasn't specific enough, and so that's one of the issues we run into a lot of times with just enforcement, is that the orders are not specific enough to be enforced. There's no, you don't have enough notice of what you're supposed to do.
And so here, neither party was living in Missouri in 2020, in January of 2020. Could the order have been enforced? The exchange was supposed to take place at a police station out in Missouri. Was that practical for either party?
No.
And in your opinion, January 2nd, 2020, was the Missouri order controlled?
No.
And how many lawyers have been involved in this situation?
In this case,
Yes.
We use some of the civil side I'm aware of. There have been, I think Sharita's had 3 or 4 lawyers, and Otis has probably had 5 or 6 lawyers.
And how many judges?
Multiple judges. I don't know, 4 or 5 judges.
Has anybody been able to say for sure what the orders are supposed to be?
Not to my knowledge.
This is a complicated case.
very complicated. I mean, it's not as simple as just taking an order and registering and enforcing it. This is involves multiple states, multiple jurisdictions, multiple courts. I don't know if they ever got to the bottom of it, but as of June 2020, when I stopped after the UCCJ conference, when the case was supposed to go back to Tennessee, I don't know if it's ever been resolved.
I have no further questions.
Right, state.
So you said that you spoke to Mr. Toussaint on January 2nd of 2020, you gave him legal advice, correct?
Yes.
And that he followed your legal advice. You testified to, correct?
That he followed my legal advice?
Yes? You believe so? You believe that's what you testified to?
Are you guys saying if I believe that's what I testified to, or if I believe he followed my advice?
My question to you is that you testified that Mr. Toussaint followed your legal advice on January 2nd of 2020.
Yes.
So was your legal advice not to turn over the child to Sharita?
At that point, there were concerns about mother's mental health. We thought we.
Object, Your Honor, this is non-responsible.
Sustained.
You can just listen to the question I have and you just answer the question. My question to you, was your legal advice not to turn over the child to Sharita? Yes or no?
I don't know that that was a question at that time.
So your legal advice as it relates to Otis Toussaint turning over the child to Sharita, it did not include him not turning over the child to Sharita.
I don't remember at the time. I was trying to explain to the police officers what was going on.
Then what legal advice did you give Otis Toussaint that he followed?
We were following the case and we're trying to get some words established. I think we followed something that we had already followed some. The case was pending. The case was pending and Sharita didn't respond. She didn't answer.
Mr. Rodriguez, the question to you, I don't think this is that difficult. March 2nd, 2020, you testified to
This is
defense.
January 2nd.
Sorry, January 2nd of 2020, you testified that on that day, January 2nd, 2020, so we're not confused about the date, that he followed your legal advice.
That he followed it?
You testified to that fact, correct?
I testified I gave him legal advice, yes.
And that you testified when Mr. Locke asked you that he followed your legal advice on January 2nd of 2020.
Right, but
That's my
the
question.
question wasn't to turn the child over to Sharita that day. She wasn't there. It was the police that were talking to.
So what legal advice specific to January 2nd of 2020 did he follow?
I'm sorry, I don't understand the question.
You testified, right? You've been testifying this to you the whole time, right? Take it step by step. Okay. You testified on his question, January 2nd of 2020. You provided legal advice. You remember answering that question? Yes.
Yeah.
And then he asked you right after that, is it your opinion that he followed your legal advice on that day?
Yes.
Do you remember that question?
Yes.
And then you answered yes.
Yes.
So, okay, we're only talking about January 2nd of 2020. What legal advice did he follow?
We're following the Tennessee court order. I told him, look, Otis, we're going to follow the Tennessee court order that says to maintain the status quo, which you have custody of the child.
And so Mr. Splott made a big point of this during questioning that courts of appeals do not order people to do things, right?
They do order. That's what they do.
They do? So you would disagree with Mr. Locke about that?
I'm not sure. I'm not sure I'm disagreeing. I thought the question earlier was if they do order people to do things.
Do court of appeals opinions and orders, do they order people to do things?
They can.
Because Mr. Locke is of the opinion that they order courts to do things. So you would disagree with him?
I don't know what his opinion is.
If that's his opinion, would you disagree with him?
That if appeals courts can order people to do things.
That they only order courts to do things?
I don't know what the Tennessee courts do, but the appeals courts can order people to do things. They can order the district clerk to do something. They can order a judge to do something.
Do they order parties, individuals to do things?
They can. I don't know.
So Is it your opinion that the Court of Appeals in Tennessee ordered Sharita and Otis to follow the status quo?
That's what their judgment said.
My question to you is it your opinion that the Court of Appeals in Tennessee ordered Mr. TOUSSAINT and Ms. Lee to do something?
Yes.
I'll pass the witness, Judge.
Defense,
And what was the status quo, Mr. Rodriguez?
The status quo at that time
Your Honor,
was,
asked and answered.
that'll be overruled.
the status quo at that time was that the child lived with Otis, who was the primary parent, had been for since 2017.
No further questions.
State,
I have no further questions.
all right, is this witness excused or subject to recall?
Excuse your honor.
State, is he excused or subject to recall?
Subject to recall, Judge.
All right, the rule has been invoked. You're an attorney. You know what that means. You're not allowed to discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state, attorneys for defense. Make sure you're available if needed.
I do have court tomorrow morning, so.
We'll make sure the court knows.
Okay.
All right, thank you.
Thank you.
All right, can I see both sides up, please? All right, defense, call your next witness.
Your honor, the defense rests.
State,
State would rest in place.
defense, you close.
Close your honor.
All right, thank you. All right, have a seat. Ladies and gentlemen of the jury, you've heard all the evidence that you're going to hear in this case, but you're still not allowed to deliberate or speak about this case to anyone. Again, I don't expect this to be in any type of media, but if you run across somebody who's trying to talk to you about this, do not talk to them about this. What's going to happen is we're going to come in tomorrow at 9 a.m. At 9 a.m., the state and the defense will be given the chance to give closing arguments to you. And then after that, I will allow you to deliberate. Does everyone understand? So we'll be back at 9 a.m. and we're going to start right at 9 a.m. All right, and thank you all so much for coming in on time. It's appreciated. Everyone, please rise. Yeah, I'm playing so. All right, thank you, I appreciate that.
Are those notes for me?
Hmm?
Are those notes for me?
Yeah, see, I did that for you.
How long have they been sitting there, Jen?
Since the break, I brought them back for you.
I didn't even see them.
All right, so we're outside the presence of the jury, and it's with regards to the jury charge. They're bringing a draft of the jury charge out to you, and I'll have you all look those over. And by my understanding, Mr. Locke, you're going to want what in the jury charge?
A mistake of law and a mistake of fact.
And State, are you ready to argue that point, or do you need a moment?
I believe that I'm ready at this time.
Okay, all right, the court will hear your argument.
So as it relates to the mistake of law, first, the penal code under section 8 says that first of all, that it is not an offense. The only way that it can be a defense is that it is in a essentially in a court order, or it is a opinion issued by an authority with the I don't want to say authority also, but with the obligation of interpreting that. I think most of us would think that as a attorney general, and so that affirmative defense doesn't apply here in that this is a court order, not a published opinion relating to the analysis and enforceability or opinion as it relates to the law. And so he was not relying on an interpretation of the law by a court in committing this act. And so I think it's proper to give that to the jury. As it relates to mistake of fact, I did not hear any testimony that relates to there was some fact in controversy that led him to believe that he could commit this crime. We think of a lot in the context of like a hit and run case where they said, I didn't know that I hit somebody, and so I continued driving, right? The mistake of fact being, I didn't know I hit somebody. And so it goes specifically to the culpable mental state, in this case, intentionally or knowingly. And so I am unaware of any testimony elicited in this case by either the state or the defense that relates to a mistake of fact. So I think both are improper for the court, for the jury to consider.
All right, it's your request, so I'll give you final argument, Mr. Locke.
Thank you. So mistake of law. And so this surrounds, Your Honor, the question of what is the valid order that governs this case? Is it the Tennessee Court of Appeals order that says to maintain the status quo? Or is it the Missouri order? Or is it none of these? These are all questions that were before Mr. TOUSSAINT when he made the decision to keep Omari until the Texas court had entered orders. And those questions are ripe for both a mistake of fact and a mistake of law defense. So let's look at 8.03b2 of the Texas Penal Code. It is an affirmative defense to prosecution that the actor reasonably believed the conduct charged did not constitute a crime and that he acted in reasonable reliance upon a written interpretation, and then I'm going to subsection 2, okay? A written interpretation of the law contained in an opinion of a court or made by a public official charged by law with responsibility for interpreting the law in question, okay? So has the court heard a scintilla of evidence about that? And absolutely, Your Honor, you've heard tons of evidence about that. You have heard that we're interpreting the Tennessee order. that we had an attorney, somebody who's charged by law with the responsibility for interpreting a law in question. He's interpreting that order, applying it to Mr. Toussaint's case, telling Mr. Toussaint, maintain the status quo. Mr. Toussaint follows that advice. And as he's following that advice, he's then charged with a crime. This is a mistake of law. It is absolutely textbook mistake of law defense.
So you're saying that the attorney who testified, Mr. Rodriguez, stated that he informed him that he was not to give custody
To maintain the status quo. And that the status quo was that Otis had custody of Omari.
So you're saying that
And that
the
relying
witness
upon
who
that-
testified, you're saying that the witness, the attorney who just testified, he testified that he informed the defendant that he was to maintain the status quo, and the status quo was
that he had
not
custody of-
giving
Yes,
visitation to the complainant?
yes,
Okay, I just wanted to be clear.
yes.
And Your Honor, if you look specifically at the mistake of law as it relates to B2, it's a written interpretation of the law, not an order, but the law contained in an opinion of a court of record, right? Or made by a public official charged by law with responsibility for interpreting the law in question. It doesn't apply in this case. We have an attorney who is not a public official charged by law with responsibility for interpreting the law. And he is neither an opinion of a court of record. So it's completely inapplicable.
And that is a complete misreading of that statute. A written interpretation of the law contained in an opinion of a court of record. Okay, the Tennessee Court of Appeals is a court of record. That is a court of record. I don't think there can be any dispute. Okay, made by a public official charged by law with the responsibility for interpreting the law. Okay, public officials, attorneys are public officials. We're members of the state bar, we're officers of the court. We're charged by law with interpreting opinions and giving that opinion to our clients who can then rely upon it. Yes, it is within the four corners of this, and we've heard far more than necessary to get an affirmative defense on that.
And Judge, if we're going to follow Mr. Lott's theory of that, then an attorney could tell his client, you can commit murder, and then it would be a mistake of law defense.
And Judge, that would be true if we had a court of opinion, a court of appeals opinion saying this person can be murdered.
All right, and what's the, so I've heard all the argument on the mistake of law. You want to proceed now with your argument for mistake of fact?
The mistake of fact is what valid order is in place.
State.
Mistake of fact would be like, I didn't know an order existed, right? Mistake of fact is that there's some fact not within his knowledge that he relied upon. This is an interpretation of a fact, right? So he has all the facts in front of him. It's not that he was without a fact to act, right? And so how I understand and read 802, it's inapplicable in this case as it relates to the testimony that was elicited.
Okay. All right, everyone.
And Judge,
All right, we're gonna come back tomorrow at 9 a.m.